All right. Why don't we get started on our afternoon? We're already doing so well. So the next topic is our education topic on electricity. So Dean, why don't you carry on?
Thank you, Mr. Chairman. Mr. Chairman, my name is Dean Temte. I work in the Budget Fiscal Division of the Legislative Service Office. And today I will start off by giving you an update to a presentation I gave 2 years ago on electrical generation in Wyoming as well as in America. When I gave this presentation 2 years ago, the purpose of it was to describe how much electrical generation had changed in America and in Wyoming over the past 20 years. My emphasis today is to describe how much electrical generation has continued to change just over the last two, from 2019 to 2021. It seems like the changes that we've seen from 2000 to 2019 have at least continued, if not accelerated, over just those past 2 years. Emily will be working the slides for me. Emily, if you go ahead and proceed to the next, to slide number 2. And again, what this slide does, it just is a description of power generation, both in the United States, actually in the United States for over 3 time periods. And that's in the year 2000, in the year 2019, and also in the year 2021. Particularly the changes from 2019 to 2021, we've seen a continued increase in power generation from both wind generation and from solar in the United States. To contrast, from 2000, over 70% of the power generated in the year 2000 was from fossil fuels. Now in 2021, that number is 61%. An interesting one point that I added to this particular presentation, because of developments within the state of Wyoming, is to talk about power generated from nuclear fuel. And if you'll notice in all 3 sections of those bullets, electrical generation from nuclear power has stayed very constant from the year 2000 through the year 2021. That amount being roughly around 20% of the total amount of power generated. However, in that very last bullet on this page, though, power generated from wind and solar has continued to increase. That it represented 9% of the power generated in 2019. In 2021, now it represents 12% of the total power generated. This particular graphic is just basically showing the same thing. It's showing electrical generation from wind power over the period from 2000 to 2021. Probably the biggest takeaway from this slide is that U.S. electric power generation from wind has increased by almost 28% from 2019 to 2021. And I think that's a significant increase. Going on to the following slide, slide 4, you can also see how electrical generation has increased from solar power as well. And that increase is larger than 50% from solar power from 2019 to 2021, from the 71,936,822 to the amount in 2021, 115,260,057. Going on to the next slide. These next two pages talk about the renewable portfolio standards and goals, which are actually in place in a majority of the states in America now. The National Council of State Legislatures has continued to monitor this particular issue. They did a report of this in 2020. They also updated it as of August 13, 2021. And what that report says is now there are 27 states that have current renewable portfolio standards. There are 3 states that have current renewable portfolio goals. One interesting point from the update of that NCSL report is we are starting to see a small number of states that are actually allowing those portfolio standards or goals to expire. And 7 states have done that. Probably the most telling piece of information on this particular slide is states keep amending their renewable portfolio standards. And as of the time of this report, most states with current or recently updated renewable portfolio standards have targets of at least 40% of their electrical power to come from renewable or clean resources. As a matter of fact, 10 states have set 100% clean or renewable requirements with deadlines between 2030 and 2050. And I know that can seem like a long time away, but if you think about it, 2030 is 7 years away and a couple months. So this is also an indicator of how quickly and how much America's energy portfolio continues to evolve. Going on to slide 6 is just a summary of the different states with the standards in place, the 27 states listed that actually have portfolio standards, the 3 states that have voluntary energy portfolio goals, and the 20 states that do not have standards or goals or have allowed them to expire. Going on to slide 7, this is just providing the same type of information that was provided in slide 2, except it is just for the state of Wyoming. You can see in the year 2000, 95.8% of the electricity generated in Wyoming was from coal, and 0.5% was generated from wind and solar power. You can see how those amounts changed, advancing to the year 2019. The numbers from 2000 to 2019 didn't change a whole lot, but still, coal was basically the largest contributor to electrical generation in Wyoming, with almost 84% of the power generated from coal. However, by 2019, the electricity generated from wind and solar represented 10.3% of the total electricity generated. And if you look just two years later, based on the EIA data, you will see that the percent of electricity generated from coal in Wyoming is continuing to go down. It now represents less than 75% of the total, 73.7% in 2021. And there's still, and actually the percentage contributed by wind and solar has almost doubled in those 2 years, from 10.3% to 19.8%, which is significant increases.
Astounding.
If you look at slide number 8, the most telling piece of information on this particular slide is if you're comparing the 2019 electricity generated from wind compared to the 2021 electricity generated from wind, that the amount of electricity generated from wind has increased by almost 103% in 2 years. Slide 9 also shows the status of solar power as well. You can see that solar power really has not changed very much in Wyoming in the past few years. The very first year it ever showed up was in 2018. You can see 2019, 2020, and 2021 were roughly the same amounts in those years. Just to show some comparisons to the state of Wyoming, this slide number 10 provides some information regarding electrical generation in the state of Montana, our neighbor to the north. You will see similar trends in the state of Montana as you've seen in the state of Wyoming, where in the year 2000, 61.2% of their power was generated from coal. You will see that number drop to 50%, just over 50% by the year 2019. But that number has continued to drop. It dropped in the past 2 years from that 50% to just under 44% for the power generated from coal. And you also see the same trends as well from the electricity generated from wind and solar power, where actually the 0% was generated from wind and solar in the year 2000. That percentage was 8.6% in the year 2019, and significant increase from that 8.6%. The contribution in 2021 is 14.1% of the total. You will also see that hydroelectric power is a significant contributor in Montana, where it is not in Wyoming. If you look at slide 11, specific to the electricity generated from wind in the years, comparing the year 2019 to 2021, Montana electrical generation from wind increased 46.3% from 2019 to 2021. Not quite as large of a percent as the increase in Wyoming, but still significant, almost a 50% increase. Slide 12 is also describing the electricity generated from solar power. Similar situation to Wyoming, where there has not been a lot of change in the past 3 years. You'll notice from 2018 to 2021, the state of Montana has generated roughly 34,000 megawatt hours, right in that ballpark for those past 4 years. If you look at slide 13, this slide is very telling as well, because it is telling about each state's electrical generation capacity. Probably the most telling thing is how that generation capacity has increased significantly in the past 2 years from 2019 to 2021. Wyoming installed wind capacity has increased by almost 75% from 2019 to 2021. Montana, that increase is not quite as significant. Montana's installed wind capacity is increased by 27.3% over those from 2019 to 2021. This final slide here in this presentation is talking about Wyoming's power generation tax policy. The top portion of this particular slide is describing the production tax on wind generation, which I believe that passed in the year 2009, if I remember right, which put an excise tax of $1 per megawatt hour levied on the production electricity produced from wind on and after January 1, 2012. you will notice that there is an exemption for on the electricity tax the tax on electricity from wind resources. Electricity produced from a wind turbine shall not be subject to the tax imposed until 3 years after the turbine has first produced electricity for sale. And the lower portion of this slide is a new entry since the 2020 presentation, which is the tax on production of electricity from nuclear reactors. And this particular tax passed, I believe it was in the 2020 session, which established a tax of $5 per megawatt hour levied on the sale of electricity produced from nuclear reactors on and after January 1, 2021. I'm sure the Department of Revenue will correct me if I'm wrong, but there has been no electricity generated from nuclear power in the state as yet, but you definitely hear about that electricity generated from nuclear power is definitely something that is coming to the state of Wyoming. Well, Rocky Mountain Power, Mr. Chairman, forgive me if I should not have mentioned a specific name.
No, we're actually good with names. It's okay.
Okay.
So just for everybody in the committee, on the floor, it's really a tradition. You don't use any proper names whatsoever, but we're pretty good about allowing it if it's not derogatory in the committee. So
that's fine. There was legislation during the last session, though, which created a pretty significant exemption for that tax that passed during last session. That was original House Bill 131, which was enacted as Chapter 103 in 2002 Wyoming session laws, which added to the exemption portion of this tax statute that no tax shall be imposed on any advanced nuclear reactor operated in accordance with Wyoming Statute 3511, 2101. Beginning in the year 2035, beginning July 1, 2035, a taxpayer shall only qualify for the exemption authorized under this subsection for any month that not less than 80% of the advanced nuclear reactor's uranium used for producing electricity was sourced from uranium mines located in the United States. So as of passage of Chapter 103 of last session, there is an exemption which that's about 13 years from now, where tax could be collected under from a nuclear reactor producing electricity under 3511-2101. I'll stop at this point and see if anyone has any questions in regard to this
questions for
information.
Mr. Temke. Go ahead, Representative Baker.
Thank you, Mr. Chairman. I probably should know, but is the power generated from the Flaming Gorge Dam, the hydroelectric power, is that Utah or Wyoming power?
Mr. Temke.
Chairman Case, Representative Baker, I would have to check into that, and I would be able to let you know within minutes after I'm done presenting it. I would just have to look up in one of the tables.
Yeah, and I think you're going to find that the dam itself is in Utah. The power producing facilities are in Utah. It's considered to be part of their resources in Utah. We provide the hydrology, but they got the credit. We do have some hydropower, but not very much. Buffalo Bill produces, Boyson produces, Alcova produces, Pathfinder. So,
thank you, Chairman Case.
you bet. Any other questions for Mr. Temke? Mr. Roscoe, Representative Roscoe.
Thank you, Mr. Chairman. Mr. Temke, our renewable growth, as for electrical generation is paralleled Wyoming, Montana. Are our tax situations the same or different?
Mr. Temke.
Mr. Chairman, Representative Roscoe, the next document I was going to go through actually will address part of that question. If memory serves, Montana also has a 20 cent per megawatt hour generation tax. They also have a 15 cent per megawatt hour transmission tax for all electricity transmitted in the state. That was at least as of 2 years ago. I confess, I did not know I was going to be talking about this memo prepared 3 years ago until this morning, so I had not had a chance to research to see if Montana's laws were still the same as they were a couple of years ago.
I think Representative Roscoe, to your point, we also had testimony in a previous committee facility that there are some local fees in Montana. So, but maybe we should let Mr. Temke go to his next piece of this, I suppose. Is that all right? Okay, yeah, Mr. Co-Chairman.
Mr. Tempe, on, I think it's page 7, your slide 7. The 2000 Wyoming produced 45.5 million megawatt hours total. And then fast forward 21, it's 43.5. So we're down a couple million megawatt hours of generation. Seems to me the old rule of thumb was always, it seems like we've always exported about 60% of our power goes out of state. Is that, do you have any more updates on that or?
Mr. Chairman, as a matter of fact, I just looked that up today to see if that is still consistent. The amount of the power generated in Wyoming that was exported out of state in 2019 was around 56.5%. In 2021, it was about 58%. So yes, the 60%, if you look over the long term, over that 20 to 22 year period, 60% is a good rule of thumb of the amount of power generated in Wyoming that ultimately is exported.
Okay, thank you, Mr. Chairman.
Thank you. Anybody else for Mr. Temke at this point? Mr. Temke, would you mind, I know that we kind of pulled a fast one on you by asking you to talk about that comparison that was done a few years ago, but we appreciate it if you could.
Oh, Mr. Chairman, it's my pleasure. I
Okay.
almost wish
You just like to grumble a little bit, right?
Mr. Chairman, I am now going to the next document, is dated September 18, 2019, which is a document I prepared for the Joint Revenue Committee at that time, in which I contacted NCSL at that time, in which they helped me to come up with this summary of the taxation of power generation in other states in comparison to Wyoming. One of our neighbors to the west, Idaho, actually has a 3% tax on the producer's gross wind or geothermal earnings. They also have a tax in place which is 3.5% of the producer's solar energy earnings. This tax is different from the tax in Wyoming, is that it is not a tax per megawatt hour, but a tax on the gross receipts from those, from that particular power generation. One thing that from this memo as well, one thing you will see, there are several states that do tax power generation, but the tax on power generation is in lieu of other taxes, frequently property taxes on the on the property in place to generate the power. Going to page 2, you will see the state of Iowa. They have a replacement generation tax of 6 cents per kilowatt hour, which translates to 60 cents per megawatt hour, a little bit more than, well, it's 60% of the tax in place of the Wyoming tax. The taxes in Iowa as well, as I had mentioned before, these taxes on this power generation is in lieu of the tax it's in lieu of the property taxes on the property in place to generate the power. Another comparison state, the state of Minnesota on the bottom of page 2. And these particular generation taxes, they are set at different rates depending on whether it's a large-scale conversion facility, a medium-scale conversion facility, or a small-scale conversion facility. And the tax is at different rates depending on the size of the facility. You will also notice on the top of page 3, the state of Minnesota also has a solar energy generation tax of $1.20 per megawatt hour on the production electricity. You will also notice for the state of Montana, though, personal property consisting of solar energy generation systems is exempt from property tax, and solar energy systems as defined are exempt from sales tax. For the state of Montana, as I had mentioned before, they've had a 20 cent per megawatt hour license tax on electricity generation, and that dates back to 1935. As you had mentioned, Chairman Case, there are also local taxes in place as well, specifically initial local government and school district impact fees. An owner-operator of a wind generation facility used for commercial purposes subject to an initial local governmental and local school impact fee for each year of the first 3 years after construction. The annual impact fee may not exceed 0.5% of the total cost of constructing the wind generation facility. Going on, proceeding at the bottom of page 3, Mr. Chairman, is North Dakota's wind generation taxation is described. It's at 50 cents per megawatt hour. The first tax, also they're also described here, grid-connected generators with capacity of 100 kilowatts or more, not produced from coal or wind, or produced from coal and not subject to coal conversion taxes, are subject to taxes consisting of the following 2 components. 50 cents per kilowatt hour times the rated capacity of generation unit, and 1 mil per kilowatt hour, which converts to $1 per megawatt hour of electricity generated by the production unit for wind generation. Wind generation and grid-connected taxes are imposed in lieu of all real or personal property taxes. Again, North Dakota is an example of a state that taxes the power generation instead of the property tax.
Mr. Chairman?
Representative Baker, please.
Thank you, Mr. Chairman. If you dove that deep into it at the time, I'm just wondering, do you know in the states that that did a generation tax in lieu of these other taxes, property taxes, was there a portion of that tax set aside to locals and to replace the property tax? Thank you.
Mr. Temke, if you know.
Mr. Chairman, Representative Baker, I would have to check on that and get back to you on that. Typic, yeah, I would have to check to see if they would end up distributing part of those taxes back to local governments, since if they're in lieu of property taxes typically are end up being collected by the local government. So let me check on that and I will let you know.
Good question. Back to you, Dean, if you got some more.
Okay. Mr. Chairman, just proceeding on page 4 of 5, describing the generation taxes for the state of South Dakota. They are at $3 per kilowatt hour times the nameplate capacity. And that's for nameplate capacity tax of wind farm and solar facility. The tax on
And
electricity.
that's an annual fee, right? Most,
uh,
that'd be,
Mr. Chairman, that I believe so, yes.
yeah. Okay,
And then also described under the South Dakota taxes, tax on electricity produced by wind farms, 45 cents per megawatt hour. And then also tax on electricity produced from solar facility is taxed at 90 cents per megawatt hour in the state of South Dakota. Mr. Chairman, just a couple of states left, the state of Vermont and the state of Washington. They did have in place a $2.50 tax, megawatt hour tax that was enacted in 1972. That was actually repealed in June 2019. Although in 2013, they enacted a renewable energy uniform capacity tax of $4 per kilowatt hour of plant capacity assessed on any renewable energy plant commissioned to generate solar power. And there's also an exemption built into that as well, exempt if the plant capacity is less than 50 kilowatt hours. There is that power shall be exempt from taxation. Finally, describing the state of Washington. The state of Washington has a 1.5% of the wholesale value of the energy produced. In 1982, they enacted an additional tax equal to 7% multiplied by the tax payable under subsection 1. So they were kind of constructing their tax base based on taxes that were already in place at the time. Although it looks like that at least back in 2019, Washington's power taxes had been in place for quite a long time, for about almost 40 years. 1982 was the last time that they were updated, at least as of the writing of this memo. And then finally in Wyoming, this is talking about the $1 per megawatt hour tax on wind generation. This does not include the new power generation tax of the $5 per megawatt hour on power generated from nuclear reactors, though.
Senator James.
Thank you, Mr. Chairman. I was just curious, did you try looking at Florida or Texas? They seem to have pretty good idea on how to attract businesses, and so I want to take a look at their tax rates if they happen to have any of these industries there. Thank you.
Dean, if you can.
Chairman Case, Senator James, one thing that was about this particular memo, this was trying to compare Wyoming with those states that had specific power generation taxes in place. Since they are not included in the memo, my recollection is that those particular states don't specifically tax the power generation, but their tax structure is a little bit different from that. You mentioned the state of Texas, and what was the other one?
Florida.
Let me go ahead and see what that tax structure looks like, and I will get back to you offline. Is that okay? Okay.
Any other questions for Dean on this memo? So Dean, this is a little bit dated. How hard and how long would it take to bring this memo up to date? What do you think? Could you do it by session?
Oh, Chairman Case,
What's the right answer here, Dean?
I can give it my best effort, Chairman Case.
I don't know if that's something somebody would like to see, if this is worth updating.
Mr. Chairman,
Mr.
I
Kochar.
think the other thing, and I've been trying to go through and do the little math as we work through it, but really there's different ways to do it. Obviously, some are capacity, nameplate capacity, et cetera, but really what's the real amount when you compare it to Wyoming? Who's got a higher tax on generation than us, or who's got a lower? I think that would be helpful as well. Just maybe there's a little tilt in for every, million megawatts, this is what the tax is. And be interesting to kind of compare that. Thank you, Mr. Chairman.
Thank you, Mr. Chairman. Any committee discussion? I mean, I think what's surprising to me is that states do different things, and we're suddenly not the outlier. I mean, I think we've always been told we were the outlier, that we were the ones that were taxing wind, for example. That's unusual, but states have different ways of taxing these things. It's complicated. It's definitely complicated.
Well, and much beyond this generation type tax that's subject to this memo are corporate income taxes, gross receipts taxes, those kind of things that are, that Wyoming doesn't have.
Yeah, go ahead, Dean.
Mr. Chairman, Co-Chairman Harshman, I was just going to agree with you on that, is that the portfolio of taxation across the states is really quite vastly different. So if you're just looking at power generation and that's it, you're probably not looking at the entire picture. As you know, and has been pointed out many, many times, Wyoming is one of the very few states that has no individual income tax or corporate income tax. It's Wyoming, it's South Dakota, our neighbor to the east. I want to say Texas as well, but their portfolio of taxation is quite different, which is a little bit of a segue to the next portion of this discussion. But in just generically comparing the state of Wyoming to the state of South Dakota, you will see that the state of South Dakota taxes a lot more of its services are subject to sales tax. Its property tax rates are significantly higher than Wyoming's. So it really kind of depends on the portfolio of taxation that each state has decided to go with.
Yeah. So just to kind of frame things, this committee has looked at, I think we've had bills either by members of this committee or from this committee to raise the solar tax to equal the wind tax. We've had bills to raise the wind tax in different forms. Dr. Halloran, you've brought that bill a few times. We've also looked at bills. We've never carried them forward yet, but we had a bill on, two bills prepared about taxing all electricity, not renewables necessarily. And we did that via megawatt hour proposal. And there was another one done based on a gross receipts proposal. And if you remember those two bills, when we looked at them in their last form, they involved kind of going back to our Constitution and allowing the taxpayers to deduct the other taxes paid, so that any property taxes, severance taxes, sales taxes would be deducted from the tax bill that a utility would face. And in those same two bills with respect to gross receipts and with respect to the kilowatt hour, we also permitted the coal companies to get credit for the taxes they pay as it rolls through into the utility. So in essence, coal-fired utility generation could deduct the coal severance tax and the coal property tax. We had those bills provided. We had them at our education session a year ago, and there was another presentation from myself. We didn't get to Mr. Temke's presentation at that, so that's why I wanted to do that today. But those are sort of the bills that we've discussed in this area. We've had lots of discussion. So the question is, do we keep thinking about this? I think I can see our former colleague, now chairman of the Board of Equalization, has talked to us in the past about needing to change how Wyoming taxes things and focus on the future, and that electricity tax was going to be important someday. So I think that she's probably right. Anyway, any discussion? Representative Yan.
Mr. Chairman, thank you. You know, I think it's interesting looking at the outline of the different electricity generation taxes in the other states. And a lot of them are tiered in some way, and it really feels like it's structured in certain ways where it's trying to compensate for a disjointed effect when a certain scale of a plant versus smaller plants that are just trying to generate for a small community, et cetera. And I do worry what that would mean if we had a flat tax like that, as opposed to something that is more like a gross receipts tax or a sales tax, because where it's built into the amount of revenue that's being made by the power, right? And sales tax is generally how we handle taxation in a lot of other arenas, and I think it makes more sense to tax it based on how much the power is selling for at any time, rather than how much the kilowatt hour is, which varies the amount of value that kilowatt hour is depending on the time it's generated, et cetera. So having a flat tax becomes kind of disproportionate depending on when that power is even generated. So my preference has always been gross receipts, and I'll leave it at that. Thank you, Mr. Chairman.
And Representative Yen, I might pile on just a slight bit. If we do gross receipts, it also is technology neutral, which I think is important to some folks. So anyway, it's thought. Representative Gray.
Mr. Chairman, I think I interpreted that as the committee weighing in on its thought on direction. I personally think that this being our last meeting, it's a huge topic, the huge surplus our state has, that this is not the time. And we've got property tax here on the agenda. In my opinion, there's no way with what's on the docket we get that done in 2 hours, 45 minutes for the 6 p.m. closing time. So I just think we keep moving. And the next interim, this could be addressed by the next revenue committee. Thank you.
Thanks, Representative Gray. Other discussion? Anybody? Mr. Co-Chairman, you got anything? Okay. All right. Thank you, Mr. Temke. That's the only thing we had on this education topic. There's another presentation, but it's just the same presentation we had before last year. And that was the one that I did. So it's in the packet too.
Okay.
All right. So the next one is kind of the general review of actions that we tabled in 2021. As you recall, at the very last meeting last year, we tabled a bunch of things to the interim. Some of those things haven't made it back on our interim. And the question is, what are we going to do? And do we make sure they doubly sleep. And so we had tabled a discussion of exemptions on services. We had previously talked about a digital streaming tax, and Representative Henderson had been very thoughtful about that. So where are we at on the actions that we took before? Mr. Co-Chairman.
Yeah, I think it's this continual learning curve, you know, I don't know, there's, I think, 6 members on this committee that are gonna be leaving the legislature, replaced by 6 other. I mean, it's just continual trying to learn. And I think the biggest thing too is continually modernizing. You know, we were one of the last states to do online sales tax. You know, until we figured out that our locals were at a disadvantage. We wanted to even the playing field. And so things are going to continually change. And as we know, you know, we've gone from, not only in Wyoming, but across the country, from buying majority of goods and paying sales tax on goods and a small percent services. Now that has flipped over the last 50 years. So most of our purchases really are for services. And interestingly enough, I think there's another sheet that talks about services. And I think we tax about 60 services in Wyoming. South Dakota taxes 150 some, Texas taxes 200, Washington State. And so there's always going to be new services, and how does that thing, and it's not going to be one fell swoop, but I think it's just going to be this constant evolution. And I think it's up to us on this committee to keep this education piece moving forward, because there's just a lot to it. Man, it takes years and years to learn it. And so that's where I'm at on that. But we're a sales tax state. We're going to remain that. And I think we want to make sure our sales taxes continues to stay modernized as you know, society changes. But, you know, when you look at some of these other states like us that don't have income taxes, you know, Texas, their state tax is 6.25. Ours is 4. Their locals 8.25. Ours is 5.43. South Dakota 4.5, 6.4. You know, so a full percent higher than our 5.4. Washington State, which is a sales tax only state, 6.5 state, 8.8 with the locals. And so we really got a great system. We just want to make sure our sales tax stays modern. And, you know, the most recent example, frankly, was internet sales. You know, digital streaming, someday we're going to have to talk about it and do it. I mean, we're the #1 digital streaming state now in the country. It's changed. We used to pay taxes when we go get the VHS. Now you don't. And so all those things, I think it's just continual education. So yeah, it's pretty tough to jump into any of that, but I think we just keep it rolling forward. Those things we talked about. It's my thoughts, Mr. Chairman.
Anybody else? Representative Henderson, please.
Thank you, Mr. Chairman. I agree. You have to look at where we are. Highest inflation in 40 years, uncommonly high rents. We have a surplus in our state. This is an area that's going to come back to us. It's an option that we have that we can exercise at any time that the legislature wishes to look at it. But right now, I think it's best to keep learning about it and being very thoughtful. Thank you.
Thank you very much. Anybody else? Okay, there's one thing that's actually not on the agenda, but it is part of the education. Oh, I'm sorry, I didn't see.
Oh, that's okay,
Go ahead.
Mr. Chairman.
I'm sorry.
I was just merely going to point out that if people do want to pay more taxes, they can move to some of those other states. Maybe we can give them a list.
Well, they are growing faster than we are, so that'd be a good idea. I do want to point out this document. It's not really an agenda item, but 2 years ago, the Revenue Committee came up with this education piece for the Wyoming tax structure. And staff recently, did you do this work, Dean? Or was that our new guy, Mr. DuPont? Welcome. Tell us about your revisions.
Thank you, Mr. Chairman. So just real quick, we just updated the numbers, brought them up to date. There weren't any major changes in the narrative that the pamphlet is portraying, and we didn't change the structure at all. I'm happy to answer any specific changes that we made or any questions about it if the committee has any.
Well, I think this has been a key educational piece, pamphlet that we've had available to the public. It answers a lot of questions. And I guess what I'd like is the committee's feeling comfortable with it, that we could go ahead and put it on the website and make it available to the public. So Senator James.
Thank you, Mr. Chairman. I do have one question.
Yes, sir.
Why aren't federal taxes included? Since that's where a lot of our taxes go and those pay for a lot of the services. Thank you.
So say your question again, I'm sorry. So what,
Why aren't federal taxes not included, since a lot of the services are paid for with federal taxes? And so I was just curious why they're not included in the numbers. Thank you.
so I think maybe the direction to the staff at the time, 2 years ago, was we're looking at the Wyoming-based taxes, kind of fitting our tax collections and comparing them to our expenditures. Certainly, we are under the influence of the federal government, and there are certainly taxes collected and expenditures made. I think that's maybe beyond our wheelhouse. I don't know, Mr. DuPont, if you kind of walked into this, welcome. If you have any comment, you're welcome to make it. If not, that's okay.
Yeah, Mr. Chairman, I'll just say this was the focus on the Wyoming state taxes.
Okay. Go ahead, Senator James.
So do the federal taxes that we pay, do they not come back here and pay for K through 12 and DOT and everything that the state pays for? So technically, they are state related. So once again, the federal tax dollars should be included. I'm just curious why they're not. So
Do you have any ideas how to do that?
that's not up to me. That's up to these guys.
Okay. Any further discussion? Representative Gray?
Yeah, Mr. Chairman, I don't know if there's going to be a formal vote on this or if it's just an absent objection thing. I just want to say for the record, I remember this, I think it was 2 years ago when this was released. And while I appreciate the work that went into it, and it's a statistical venture in many ways, I don't agree with the overall recommendations and the tone of what it's trying to get at, which is that, and we've had this debate many times, and it's my last meeting here, so we don't need to get into it again, but I just want to state that Wyoming has more than enough revenue across a boom bust cycle. We've seen that time and time again. We're seeing it here actually again because we've entered a boom. And the problem is that the legislature has to have the discipline not to appropriate and to save in those years when we are not as flush, when we are very flush. So I think this gets to a different tonal point, which is that it's the view of some that volatility should be fixed with increasing. But if you look at across a boom bust cycle and you include the mineral revenues, it's the highest per capita tax revenues in the nation, other than maybe Alaska, depending on how you calculate it for the same reason. And they obviously do that. They send out a mineral royalty check to every citizen in their state. So I don't know if we're taking a vote or anything. I just wanted to put that out there in terms of my view on this brochure. Thank you.
Thank you. Anybody else? Anybody? Is it useful? It's useful to update it, supply it to the public. People can draw their own conclusions. Okay. How many would like to see us put it up on the website as something to talk about? It's just a show of hands. I got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. How many would be opposed to putting it on a website? 3. So I think if there's not objections, not an official document in any kind of way, it's a guideline, and you can draw your own conclusions, and let's go ahead and make it available to the public. Thank you very much. The next issue that we've left hanging from our very first meeting was the discussion of limited liability companies and trusts. And if you recall, there was That was in the days when the cowboy cocktail was the thing that everybody was talking about. It seems like that was a long, long time ago, but it really wasn't. It's only just, a matter of months. And is there any feeling that we should continue that exploration as we go forward, maybe the next interim, or does anybody have any ideas for private bills? Where are we at on that topic? Or is it just, it's not an issue and we're going to go forward?
Mr. Chairman.
Who's that? Representative Sweeney.
So I won't be here, but I would recommend that this be an interim subject for somebody to produce. I've had a constituent that I respect a great deal there in Casper that's represents some very wealthy clients in our state. And it's a lot more complex than I originally envisioned. And I think there may be some ways with our LLCs to perhaps address the situation. But being the complexity of it, today's not the day. And perhaps that could be possibly, if adopted, as an interim subject for next interim.
Thank you. Anybody else? I might point out that this might not necessarily be the right committee for that either. I mean, it could go, I suppose corporations could be involved in that. Might possibly be. Are there any other thoughts? As you recall from that discussion in the spring, that the issue with trusts is that they're not a public thing. And you don't have to file documents anywhere to register a trust. Trust just, they can be a very private, not in the public eye entity. LLCs are different, of course, because LLCs enjoy the protections that the state of Wyoming's law and now our Chancellery Court and all these things that go with LLCs. So they're a privilege. And so it's the combination of when a trust holds some of its property in an LLC was where some of those shenanigans are about, because it provided for anonymity of the business activity. So there are ways that I can think of. One would be you might require a different level of reporting about ownership and other aspects of an LLC if the owner is a trust. That's a possibility. Right now, if you're an LLC, you don't have to divulge your the ownership interests or anything. You do have to have a registered agent who knows that stuff, so that if there's ever an official legal connection, they can go to the registered agent and connect with the owners of the LLC. Now, it's possible we could require a little higher standard for LLCs that are held by trust, and I'm kind of interested in that approach. It's also been suggested that we have different requirements, which we have two kinds of LLCs, anonymous LLCs and non-anonymous LLCs, and that you pay for the privilege of being an anonymous LLC, and that has a higher licensing fee. That's been suggested. So we're not out of the woods on any of this stuff yet, but we have a long ways to go, and it's obviously not a subject for today. But those are some thoughts maybe some people would want to work on, and I haven't figured out a way to really close that topic off. Any thoughts? Who was that? Representative Henderson.
Thank you, Mr. Chairman. Along those lines, I think it would be timely to include in the trust discussion the extent, if any, to which there's a foreign ownership and participation, particularly in our state. Wouldn't you agree?
Oh, Mr. Chairman, I am Mr. Chairman, so I'll just, sorry about that. But certainly that was a subject of speculation in all the articles about the cowboy cocktails, that this vehicle available under Wyoming law was potentially allowing money that had bad sources originally, or, foreign interests to shield money in Wyoming. So I guess that is a concern. I will say, though, that since our meeting in May, I think it was May, the federal government has actually finished their requirements for disclosure by corporate entities. And some of the people out in this audience would know this better than I, but it's much tougher than it was before. And so there certainly is federal requirements that may make any additional state requirements unnecessary. I mean, that's a fair thing to ask. So we should remember that right now. But so we'll keep looking at that. Maybe we'll be looking at that in a different committee if that's still an issue. Corporations might come to mind. All right, that's everything on the education sessions. Is there any public comment in the education area? Anybody want to make public comment on our education topics? Mr. Garrett.
Mr. Chairman, members of the committee, Richard Garrett, citizen of Wyoming,
Welcome.
resident of Cheyenne. You got some great learning materials here today. I really applaud the Legislative Service Office for their work. It's certainly given me a lot to think about. I want to briefly describe why I'm interested in this subject of energy. As you probably all recall, I've advocated on behalf of clean energy, better land use, and conservation in the state of Wyoming for a very long time, and that advocacy has not changed in any way. Now I'm a volunteer, I'm kind of a member, if you will, of a little group called the Wyoming Energy Forum, and as you approach the interim, or think about the interim, I should say, and what Wyoming's energy future might look like, I guarantee you that the Wyoming Energy Forum will be glad to have a seat at the table and learn and share what we learn with members of this committee and anybody that succeeds you as members of this committee. I would only offer this. We've seen, and Chairman Harshman, Co-Chairman Harshman, has pointed out, and it's been affirmed by the LSO, that about 60% of Wyoming's energy resource is exported to other states. And that's a good thing. You know, that's what we do in this state. We sometimes add value, sometimes we simply ship a resource, but we are an energy producing state. We are producing energy for the benefit of about 6 states, at least 6 states that have renewable portfolio standards. And they are asking us to do something on their behalf that is having potentially profound consequences on our state's conservation, our landscape, our future generations for 30 years or more. And I think that we really need to take that into account. I'm not going to kid you. I believe climate change is real. Its consequences can be seen almost every day, and we need to do something about it. But I'm proud to say that in Wyoming, we are doing something about it. We've heard about carbon capture, utilization, and storage. We have the ITC, where tremendous research is being undertaken to find carbon neutral products that can make a meaningful difference in our lives. University of Wyoming School of Energy Resources is an important component of all of that work. I would submit that those that ask us to do something should pay us to do that something. That's the nature of a transaction. So perhaps during the interim, we can think about ways where those folks in those 6 states and others that are benefiting according to their policies from renewable energy development in this state pay a little bit extra to offset the costs of that development to the people of the state of Wyoming. So that's all I'd share with you for now, unless you ask any questions, and I'll be glad to try to answer them.
Questions for Mr. Garrett? Thank you, Mr. Garrett.
Thank you.
Thank you very much. Is there anything online? Anybody else want to address Mr. Nelson? Welcome. Is your mic on, sir? Green light. You're looking for a green light at the bottom.
Yes, thank you.
There you go.
Good afternoon. My name is Thor Nelson. I'm an attorney with the firm of Holland and Hart. I'm here today representing the Wyoming Industrial Energy Consumers. It's a coalition of some 19 different companies in the state of Wyoming, oil and gas companies, manufacturing companies, trona mines, all sorts of different companies who are gathered together for the purpose of representing the interest of electric consumers. Because what all of my clients have in common is that they consume a great deal of electricity, and for most all of them, it is their largest single cost for doing business in the state of Wyoming. I know you have a very busy agenda, so I won't belabor this subject, but I did want to just come up and let you all know that we certainly appreciate the fact that the committee continues to consider these questions. How we deal with electricity issues is a very important issue for the state of Wyoming. However, I will also agree with the sentiment that was expressed by Representative Gray that these issues, especially the taxation of electricity, is a very complicated issue and one that has a lot of moving parts and a lot of different nuance that I think need to be understood with more expansive discussion than may be available at this point in time. So we certainly appreciate the idea that while we have those discussions, those probably aren't the kind of thing we can do today. Certainly, we're open to being involved in those discussions going forward in a future interim process or otherwise. As a general principle, my members oppose higher taxes on electricity, but a lot of it depends on how the taxation is done, and there's a variety of reasons, which I don't need to go into today, because we'll hopefully talk about that at some other date. But I just wanted to rise in that sense and encourage the committee to set this off for now, but not forever, because there certainly are some complicated issues that are worth considering and discussing in more detail. Thank you.
Thank you, Mr. Nelson. Any questions for Mr. Nelson? Representative Sweeney.
Thank you, Mr. Chairman. Thor, thanks for being here today. Question I've got is it possible, like Mr. Garrett mentioned, with FERC and everything else with the regulatory complexities of the export of the electricity, on putting that burden, and Senator James has actually, contended that we should be looking at this as far as having those states that are mandating on our folks how that works. And I think it's valid to have those other states pay, but is it possible to do that without totally upsetting the apple cart?
I think it's an interstate commerce question. Mr. Nelson.
Mr. Chairman, Representative Sweeney, the answer to that is it's complicated, which I know that's an answer that will surprise no one. The thing you have to remember about the electric industry is that in Wyoming in particular, there are 3 different segments, and the answer to the question is different depending on what we're talking about. So for example, a portion of the electricity that's generated in Wyoming and consumed in Wyoming is done so through the federal power agencies, Bonneville and Western Area Power. And how they, if a tax were applied to them, how they might then roll that through into their customers and how they would pass that on, and if they could pass it on, is the subject of a complex set of federal laws and FERC regulations that apply to the federal power agencies. Then there's a second bucket of electric producers, and that's the electric cooperatives. And that includes both Basin Electric, Tri-State Generation and Transmission, and then all of the subsidiary cooperatives, the rural electric cooperatives that serve so many of the customers here in the state of Wyoming. Those have a very different regulatory structure, both at FERC and at the state of Wyoming PSC. And their ability and how they might choose to deal with an electric tax and who they might assess that on and how they would choose to assess that is another kettle of fish. But what I can tell you about that part is because of the way that Wyoming regulates or in this case, doesn't regulate the way that Basin and Tri-State charge their rates, what they would do with that tax is not something that the state of Wyoming would control. Then you have the third bucket, and that's the investor-owned utilities. And that includes, most importantly, Rocky Mountain Power, Black Hills Electric, who serves the Cheyenne Light area, and Montana Dakota Utilities, who serves a little tiny area right up on the Montana-Wyoming border. Those three entities, now it's yet another different question about how and the extent to which that tax might be treated. And in the case in particular of Rocky Mountain Power, who is by far the largest of those three, you have the very complicated issue of what's called the multi-state protocol, which deals with the essentially 6-state agreement between Wyoming and the other 5 states that PacifiCorp serves about how costs are shared and allocated. And that's another kettle of fish in terms of the ability and how and whether and the extent to which these costs can be passed along. So I'll leave it at that, but other than to say, there are restrictions and limits on how these taxes might be treated. There are restrictions and limits on how they might be charged to customers and whether they would be Wyoming customers or customers in some other state. And so that complexity is something that, as I mentioned earlier, leads to a recommendation that this be considered with a longer lead time, with broader discussion, because it's a very complicated issue. And if the goal is, how do we figure out how to assess a tax on out-of-state people? It's a very complicated way to try to figure out if it can be done, and if so, how it can be done. And that's the kind of thing which may be meaningful and might be better answered with more time and more discussion.
Thank you. Dr. Hallinan.
Well, thank you, Mr. Chairman. I'd ask Mr. Nelson, since you're in the business of buying electricity, a very simple question that maybe you could give a very simple answer to.
I bet not.
Which power source do you find provides the cheapest price for electricity for you? Is it coal? Is it wind? Is it solar? What is the cheapest form of electricity you buy? Thank you, Mr. Chairman.
Well, Mr. Nelson. It's all yours, buddy.
There you go. Mr. Chairman, Representative. So my clients mostly buy power from Rocky Mountain Power, although they oftentimes bleed over into the co-op areas. But I'll focus my answer on Rocky Mountain Power because that's the utility that I know the best. And in the 22 years that I've been doing this work for Rocky Mountain Power, historically, the lowest kilowatt hour priced power on the Rocky Mountain Power system comes from hydroelectric. That's the cheapest. And the reason it's historically the cheapest is because these plants, most of the hydro plants are decades old. They were federally subsidized at the time they were built. They've been heavily depreciated. And so the run cost for the hydro plants is, in most years, unless it's a bad hydro year, unless there's very little rain, most years the hydro plants are the cheapest.
Oh, I got the finger there.
Well, thank you, Mr. Chairman. If I may have a follow-up. That isn't choosing between coal and renewable sources. Do you have any estimate on those differences?
Mr. Nelson.
Mr. Chairman, Representative Hallinan. So that's an interesting question as well. So relative to coal versus renewable, that has changed over the time that I've been doing this work. And I think you see some of that change in the information that was presented earlier. When I started doing this work, coal was by far cheaper than renewable resources. And every year it has gone by, that gap has closed. And in some cases, with some resources, that gap has flipped so that some renewable resources are cheaper than some coal resources. But it's a complicated question because there's two factors that are in play. One is the quality of the renewable resource and the level of tax support that goes into that renewable resource. That makes a huge difference. And if you have a high quality resource that's subject to the maximum level of tax benefits that the federal government has offered over the years, those can be very cheap. Conversely, on the coal side, the biggest dynamic, there's two pieces. One is whether or not federal air quality regulations have required those coal facilities to place new pollution control devices on the coal plants, selective catalytic converters, the SCRs, which I'm saying wrong. I got the acronym right, but selective catalytic reduction, that's the R.
Yeah.
Where you've had to retrofit the coal plants to deal with environmental compliance, that has caused those prices to increase pretty significantly. And so that's been another contributing factor between the dynamic that you saw where those coal prices have been moving up, at the same time the renewable prices has been coming down. So as we sit here today, what I know about the Rocky Mountain Power System is that in any one given hour of the year, they are dispatching their coal facilities a little bit less and less every year. And that's because of the cost increases tied to operating them. But there are still lots of hours of the day and lots of time where the coal is the best option, and the best option that's available. And that's particularly the case when you get into the nighttime hours and the solar facilities aren't operating, or you get into those periodic times when the wind isn't blowing. And so it's a complicated answer to what is a simple question, and I apologize for that. But that's been my experience with the relative cost and benefits of those resource mix over my career.
Thank you. Is that good, Doctor? You bet. Senator James.
Thank you, Mr. Chairman. So would you say, with what you've observed, that it's almost like the more government involvement, the more it steers towards renewable resources versus coal, as far as funding goes?
Mr.
you.
Nelson, if you can, do your best.
Mr. Chairman, Senator, there is no question that in the electric sector, the government plays a huge role in the selection of resources, both in terms of portfolio standard requirements, both renewable portfolio standards requirements and the reliability standards that this legislature enacted recently, in terms of the tax structures, in terms of the incentive structures. It's hard to find a resource that where some legislature somewhere hasn't put their finger on the scale in terms of what is the right resource, which makes it very challenging to answer sort of a simple economic question of what is the right answer, because there's so much federal and state involvement in every one of the resource mixes that clearly plays a big role in what the decision is in terms of what resources get built to serve loads.
Okay. Anybody else? Thank you very much, Mr. Nelson. It's good to see you.
Thank you very much. Appreciate your time.
Anybody else, or shall we move on to property tax? You thought this one had pitchforks, you wait for the next topic. So is there any other public topic on the educational one so far? If not, we would move to the next item on our agenda, which is property tax issues. And coincidentally, we're only 4 minutes behind after all that. Isn't that amazing? And so how did that happen? Well, so anyway, we have property tax relief bills, and Mr. Co-Chairman, I kind of, do you want to chair the rest of the afternoon, or you want me to keep going, or? Oh, thank you very much. So I think we have kind of these different areas of this, and one, remember, we have to get to the Board of Equalization, and they've got some proposals for us that we start. We have them as second on the list, but I'm wondering, would there be any objection to swapping that? What do you guys think? Would the Board of Equalization be comfortable going first? Because I think the others could drag on a little bit. Is that okay? Would that be okay with the members? And anybody else? Is there? I don't think it'll take very long, and it's not a big shakeup of the agenda, but we could get the Board of Equalization out of the way since they've been very patient. So why don't you come on over?
Mr. Chairman, maybe we could just move these as a consent list.
We might be able to. How's the reunion going?
You and me.
There you go.
Thank you, Mr. Chairman.
Go ahead.
I'm going to defer to Marty Hartzog, who's the vice chairman of the board, as he's sort of the legal mind behind all of this. I think we've gone over these issues a few times. There's certainly, I don't know that we've reached consensus completely on both bills, but One of them is a technicality that came out of the Supreme Court that Marty will explain, and the second one is an issue that comes up a lot as we talk about how the remand process from the county boards works. So that's what the two bills are, and I'm just going to turn it over to Marty if that works for you guys.
Okay, Mr. Herzog, welcome.
Good afternoon, everybody. Just by way of reintroduction, Marty Herzog, I'm the vice chair, been with the board now for 7 years, almost 8. Was with the Attorney General's office for 17 years and have been working with tax issues since 1998. So very familiar with everything that you're discussing. The problem that came up a couple years ago, it came up in a mineral tax case, but it seems to be reappearing. Had a case, mineral case, fairly involved, and the department and the taxpayer were before us, and they had not addressed a pretty significant component of the statute. It's a valuation case. And so we went back to the parties, and it really was possibly dispositive of the issue, but neither party had raised it. Purely legal. This is a Solvay case. And the ruling just came down from the Wyoming Supreme Court some time ago, answering the ultimate question. But what happened in this case was we asked the parties to brief it. And they came in and briefed it. We had argument on it. And then we looked at it and decided the case based on that issue. The taxpayer disagreed with what we did and argued that we didn't have the authority to do that. So the Wyoming Supreme Court looked at it and says, no, you were not permitted to raise the issue that the parties did not raise, even though it was right there and it was a legal question integral to the resolution of the dispute. There was a two-judge dissent, so we had a 3-2 split at the Wyoming Supreme Court. And what basically that says is that if the two parties before us bring an argument as to the construction of a statute, we are limited to what they argue, one or the other. Now that was a problem simply because in this instance, and just to finish up the story, the postscript to that is the case went back, they resolved it that year, it came back the next year. It was presented, the entire case with that issue was presented, went all the way up to the Wyoming Supreme Court. Same resolution, and the Wyoming Supreme Court agreed with how we resolve the legal part of it. So what we are asking for in this bill is just a clarification that when a dispute is brought to us, the language in the statute now says that we have the authority to interpret and construct statutes when we resolve tax disputes. And what we are asking for is a provision that clarifies that that includes all of the hats that we wear, whether it's in our investigative authority or as a judge or a tax court when we are resolving tax disputes. It's a pretty straightforward provision that we put together. It just clarifies that if we see an issue that the parties don't raise, we are permitted to raise that issue to the extent it's required to resolve the dispute. So I can elaborate. It's come up in a number of cases after. We've come across appeals where the parties have missed something in the statute, and we are basically resigned to dropping a footnote and saying, well, here's a question that you didn't raise, but we don't have the authority to look at this dispute from that perspective. And oftentimes it's the elephant in the room, and as it was in this case with this Solvay appeal. And so it's very awkward, and it's hard for me as a tax judge wanting to do the best work and make sure that we don't put into law a ruling that's based on improper interpretations of the statutes, which is basically what we would have had to do in Solvay. So that's kind of where we're at with that question.
And then Vice Chairman Herzog, so you're proposing 23 LSO 0060, right?
Yes, Mr. Chairman.
And that amends Title 39, 11-102, and it adds the language that's on, if everybody has the bill, it's on page 3 of the bill. Am I missing any changes above that? I don't think so. I think it's just all
No, that's the statute that defines our
Yeah,
jurisdiction.
it's just to get there. So they have, the first page, there's actually no changes in the bill. And Josh, correct me if I'm wrong too. But then it adds on page 3, the new language under Romanet 4, and it adds a couple of paragraphs. It says, "The authority of the board to decide all questions under this paragraph shall apply to questions related to the board's adjudicative and regulatory functions, period. When deciding questions under this paragraph, the board may address issues not raised by the parties and is not limited to the legal interpretations presented by the party. And the board shall decide questions," and that must go on to be existing language.
Yeah, there's a list, maybe 20 or so separate authorities that we have, all as part of our authority to regulate assessors and resolve disputes between the parties. So none of that changes. All this says is we can resolve an issue comprehensively, and we're not limited to the interpretations of the parties. We obviously don't have authority to force anybody to be in front of us. We're still a court. We have to have a justiciable dispute in front of us. Two parties that are at odds. We have to have that. So this doesn't really expand our authority. It simply clarifies that if you come before us with a dispute, we get to look at the entire statute. We get to look at it so that we get it right. You know, the phrase you'll hear in some of these rulings is peri materia. Well, peri materia simply means that we are going to look at the statute as a whole and not look at just one little part of it, because doing so, you might miss something else in the statutes that is pertinent to the dispute. Well, after that ruling, what the court was telling us that it was that we could only look at what the parties brought us. We were not permitted to look at any other part of the statute or any other aspect of the dispute, even if it was germane to resolving that dispute, which was, that was kind of a difficult a pill to swallow. And so that's why we're here, because it certainly doesn't, I just think that we as a tax court have to be able to do the best job to resolve the dispute and not be limited to what the parties present.
Okay, thank you. We'll start with Representative Gray and we'll work around the room. Go
Mr.
ahead.
Chairman, thank you. Looking back to April, when you brought these potential reforms, this was always the one that I had the most issue with. And the reason in opposition, the reason is that if someone hires an attorney that doesn't make the correct argument, you can't respond to a negative. So if you're deciding to make an argument that plaintiff declined to make, how does defendant respond to it? I mean, and that's the problem here, is that you have to be able to provide a forum for the other party that is the loser in your decision, and there always will be a winner and a loser, to be able to respond. And if the other party's attorney doesn't do that, you can't, because it's not there, that argument. So that's the problem, I think, with this change. Thank you.
Did you wish to comment?
Mr. Chairman, Representative Gray, I'm not sure I understand. All we're saying is that if we see a point, a statutory phrase or a rule that the parties haven't considered, which is what happened in the Solvay case, we would like the parties to address it. We're not saying that we're going to make a decision without allowing them to address the point. And that's in fact exactly what happened. In the Solvay appeal, they came before us, and when we were looking at the record and the evidence after the hearing, we said there's a whole part that they had not addressed, an important component in the statute. It wasn't evidentiary at all. It was clearly just a provision in the statute, how the valuation method worked together. And so we actually brought the parties back, said, let's take a look at this, and we would like you to address these questions that we have with respect to these provisions. Gave them that opportunity, had a full-blown oral argument so that they could consider that. We also allowed them to submit additional materials if they so chose. Then we proceeded to resolve the appeal with that additional input from both parties. So this is not something that we do to ambush or force a party into something they don't want to discuss. But oftentimes the parties don't come in having looked at everything. And in the law, especially in tax, things can be fairly nuanced. And so it's important that we have the ability to require the parties to consider everything that is relevant to their dispute.
Okay, follow up?
Okay, that answers the one angle to the question, but, you know, then there's a deeper thing here, which is that, Mr. Chairman, if there was obviously a loser here, which I guess was the taxpayer when you went through the narrative. I mean, they had a better attorney, and or I guess the other party didn't do a good job. And ultimately, I don't think that's the job of the Board of Equalization to put, you know, ground put their feet in the ground when someone's not doing their job for their client to the fullest potential, which I guess the taxpayer was the winner here in this, and I always lean towards the taxpayer. I am elected, so, but, you know, it's, so I guess, I think probably in these situations, government is gonna be the winner on this, because usually the taxpayer is coming in with someone that deals with these cases that has this specialty. And I just think that, you know, the taxpayers should have this advantage. Thank you.
Thank you. Comment? I think there was a question in there.
Oh, Mr. Chairman, Representative Gray, in this instance, the taxpayer had the best legal counsel that's available here. And it really had nothing to do at all with the quality of representation. It was just an aspect of the valuation that the parties had kind of skipped over. And when we brought it to their attention, it was just something that we believed that the parties needed to address as part of their case, and they hadn't. And it was actually critically important at the end of the day. And the Wyoming Supreme Court ended up agreeing with us on that particular.
Are we going to do it back and forth, or can we get other questions in? Okay.
Mr. Chairman, the way I understood your description, Mr. Herzog, is the taxpayer felt that it was not handled afterwards when you brought up this case correctly. And then they went to the Supreme Court and said, well, this wasn't brought up originally. And that was decided on a 3-2 that you could weigh in, even though the parties hadn't originally did that. Did I not understand that correctly?
Go
Mr.
ahead.
Chairman, Representative Gray, the parties had not originally brought that as part of their dispute. And then we required that they come back and address it when we were deliberating, and we had an additional proceeding and resolved it on that basis. And the Wyoming Supreme Court determined that we did not have the ability to do that when we have the hat on, the adjudicative hat, that we had to basically play the game as presented by the parties strictly, and we were not permitted to look beyond the case, the authority as presented. And that was, I mean, there's no court that actually is limited that way. Courts have the ability to always look at a dispute in its entirety, even if the parties haven't addressed a part of it. The courts are not going to resolve a case that ends up with an incorrect decision when they can see that there is authority that addresses the question. So it's really an odd ruling in terms of our function, and it's specific to the statutes that the court looked at in terms of our jurisdiction. So it's an unusual ruling.
And so if I understand your testimony, and just looking at everybody here, you're saying that a court could do what you're asking to do. And so, and that in this case, you're limited, but if it had been a court proceeding, the court could do exactly what you're suggesting. Bring the parties in and say, look, we want to know more about this.
Mr. Chairman, yes, it's the courts have ample authority to resolve disputes to get to the correct decision. And if the parties come in, oftentimes pro se parties, and they haven't looked at something, courts are usually very helpful to explain to those parties that here's something you may have missed, you know, and a lot of times it's the end of the dispute. But courts have inherent authority to resolve the dispute presented to them based on the law, that's on the books, yes. Even if the
Even
parties,
parties don't raise the issues.
absolutely. If it's a part of the dispute, if it's part of the dispute,
I
yes.
understand. Okay, let's have other questions. Representative Sweeney.
Thank you, Mr. Chairman. So let me try to ask this question correctly, but my problem is if I understand properly from our County Board of Equalization on cases that have been taken onto the state, if the evidence currently at their disposal, even though it was brought forth by the taxpayer and demanded it get placed into evidence, and even though it wasn't decided on at that point, or what you're saying is once it reaches the state on that appeal process, even though it's been brought forth by the taxpayer in their appeal process, would this correct the problem of you guys not considering it because the County Board of Equalization, according to you guys, didn't produce everything?
Go ahead.
Mr. Chairman, Representative Sweeney, no. This is strictly when
Is your microphone on? Just checking.
Yes.
I'm gonna pull it a little closer, I
Pull
think.
No, this is strictly when we are the adjudicative body in the first instance. We're the trial court. So it's always, this is just when we are addressing fights between the Department of Revenue and the taxpayer. When we sit as an appellate body from an appeal at the local level, we take the record as it's presented. Now, there are provisions in our rules which allow the parties to try to supplement the record that we receive, but that's an entirely different issue. And this is not addressing that in any way, shape, or form. So don't confuse what you had been hearing about in the local county board appeals with what I'm talking about here. This is strictly when we are conducting hearings and resolving disputes between the department and the taxpayer.
So let's just be clear, this would apply for state assessed property.
Yes.
Because you'd have original jurisdiction there,
Yes.
right? And it would apply in cases where a local issue was certified to you, which the county commissioners can do, right?
Correct.
Or the county board.
Correct.
Are there any other instances that would apply where you'd have I say original jurisdiction, I know that's not quite what I want to say, but you understand what I'm trying to get at.
I do, Mr. Chairman. Our investigative authority, we already have it because the court, that's how they broke it down. They said we have the authority to do this when we investigate ourselves. We have that. It's a leftover from when this board was pre-state, 100 plus years ago. We had this investigative authority that is really kind of hard to understand. So the court said that's when we have it. And when we sit in a regulatory capacity, we have this, but not when we sit as a tax court, which is really, really unfortunate. But so when we sit in an appellate capacity, we have to take the record and look at the decision that's made by the county board. And we have to consider whether it's legal and issued in accordance with Wyoming law. Not a problem with this provision here.
So in essence, you're not redoing the county board's work, you're judging the county board's work.
That's correct.
Anybody else? Representative Henderson.
Thank you, Mr. Chairman. I hope I'm not putting too fine a point on this, but on line 12, page 3, and it says the board may address issues not raised. My question has to do with, is there a need to consider a qualifier on those issues, kind of along the lines of your explanation, in your view?
Mr. Chairman,
Vice
Representative
Chairman.
Henderson, I'm happy to, anything that makes it more clear. I certainly, I can't think of any ways to qualify that. The issue is, that was the problem, is they didn't raise the particular issue, but it was absolutely at the center of their valuation dispute. And it related to specific language in the statute. Yeah, and so much of this, ladies and gentlemen, is part of the esoteric problems that we have with mineral tax law. You have a code that started back in the 70s. Remember, the severance tax didn't start until 69. And as it goes forward, it makes little changes in the concept of a point of valuation, and all of that is there. And then when they reiterate or create a new tax run, they change things, move things around a little bit. Sometimes they keep language, sometimes they don't. And so what happens is you get kind of a mix and match of different provisions. And then you get questions about what was intended. So the mineral taxes are incredibly nuanced and they just lend themselves to a lot of disagreement. So that's the problem. You don't have that with sales and use tax, which is pretty straightforward. And so what we had here is, an issue that jumped right out of their dispute that they didn't raise in terms of how you look at the valuation statute. Still part of their dispute. It wasn't as though we were saying, well, you wanted to talk about this. Well, now we're going to force you to talk about this. No, it had to do with how they were applying the overall valuation methodology specific to what they were fighting about. So it was one of those just really odd, items that evolved out of their dispute, which they didn't look at, even though we had rulings from this board addressing that general point of law. This is why it was so frustrating that, when it went up to the Wyoming Supreme Court and they said, well, no, you had to look at just those issues that they presented, even though what we were trying to discuss really resolved the question completely differently. And so if there's a way that we need to, I'm assuming you're talking about issues, if there's a way that we need to change that, I'm certainly open to that. I'm not sure how we would do it, but anything that, because like I said, in about 6 cases since then, we've had to drop footnotes that said, well,
If you would have done this.
we're kind of hamstrung here, but here's a question that you didn't consider. And in several of those, it was kind of important. So,
Chairman,
Follow up.
if I may then, how would you feel about something along the lines of may address any germane issues, including but not limited to?
anything that
That leaves you and
Well, let's
the
go through the
people
chair, you
involved.
guys.
Excuse
Come
me.
on, let's do that. Okay. Go ahead, Representative Henderson.
Thank you, Mr. Chairman. Sorry. I was on a thought. It protects the court, but it also protects the parties to the case, right? If you think about it in a non-biased way. And that's what you're about in your adjudicative process, I believe. Wouldn't you agree?
To you,
Mr. Chairman,
Mr. Vice
sorry
Chairman.
about
That's
that.
okay.
break of, absolutely, Representative Henderson, I'm okay with any kind of modification to the language, just trying to keep it as tight as we could so that it didn't turn into, too much of an onerous read, but that's anything that, gets to the crux of what we're trying to do here is absolutely, I would love to do that.
Okay. Anybody else questions on this one? What I would propose to do, I'm sorry. We'll get to you next, Representative Jennings. I was going to have you go through the other bill too, and then we'll have both, and then you can vacate and we can hear from the public and kind of do both at the same time. It's a little bit unusual, but that might be more efficient. So Representative Jennings, I didn't mean to get ahead of you. Sorry.
So, thank you, Mr. Chairman. So, according to your testimony here, but I see a problem here that maybe somewhere up down the road, sure, not with the current Board of Equalization, but it seems like eventually you're going to have someone that is going to tell someone that they are going to have to take this part up. And so perhaps there was you know, and I'm not saying it was in this cases that you're saying about, but maybe there was a reason they left that out. Maybe there was a reason they didn't want to talk about that. And now you're saying that the court is going to say, you are going to bring this into the equation. And so you know, I'm not saying that your group of people would do that, but somebody up the road might. And pretty soon you've got the court interjecting itself in as either part of the prosecution or part of the defense. And it seems like there could be a problem somewhere up the road with this. Could you address that a little more?
I think the chairman is weighing in on this. So Chairman Mockler.
Mr. Chairman, I did want to weigh in a little bit. In 1995, when we split the Board of Equalization and the Department of Revenue, Senator Enzi and I put in the bill that said that it was an inconsistent thing to have the Department of Revenue overseen by the Board of Equalization when the Board of Equalization ruled on everything that the Department of Revenue did. So Senator Enzi and I split the two and created the Board of Equalization. And amazingly, this was before computers, so I did this all in my living room, and I cut and paste the entire statutes that exist, and everything that went from that the Board of Equalization did, I put in one pile, and everything that was relevant to the Department of Revenue, I put in another pile, and then Mark Quiner tried to put it all together. We put it all together. So it was more of a remnant than anything. It wasn't an intent not to, because if you go back over the course of the last 30 years, 40 years of the Department of Revenue, of the Board of Equalization hearings, this was already assumed that it was a possible thing, because there are a lot of opinions that the board operated under what we operated under the Solvay case. And so I don't think it was just more that it had finally made it to the Supreme Court, and they said, you guys never clarified that. You took what was a remnant, you just didn't clarify it to say that it applied today. I think the other thing, and it goes to the point of the taxpayer, you're assuming that this isn't an efficient way to do this, but it's more efficient, because in this case, the taxpayer had to come back again and go through the entire process, through us, through the district court, and through the Supreme Court to get answered what we'd answered in the first question. And so I don't know this for a fact, but I bet those very, very, very expensive good lawyers cost that taxpayer an awful lot of money to have to go through this process twice to get the same question answered. And that's just not a very efficient or expeditious way to spend your taxpayers' dollars. So I don't think this was to give the state a benefit or to give either party a benefit. It was simply in the process of how we had worked as a Board of Equalization in the past. It just had never been clarified to the extent that the Supreme Court felt that it was time to clarify it if you want to continue to act in what is really an efficient judicial manner. So that's kind of, I hope, answered your question.
So the end result is it's your fault. This whole thing. Follow up, Representative Jennings.
A short one, and I do like that, your answer to that. And the clarification, actually, I can see. That makes sense to me, but the idea of a court coming along and saying you're on trial for something, or you're in the middle of a trial, and then the judge says, oh, by the way, I noticed that you didn't take your garbage out on the right day, and so we're going to add that one too. You should go back and address that. Seems like it could lend itself to an impropriety from the court at some point.
Mr. Chairman?
Go ahead.
Remember, anything we do is still appealable. So if we really messed up when we went out and said, you looked in the statute, and this is where comprehensively we think you should have looked at the whole statute. You only looked at part of it, and that goes to what Marty was saying earlier. So we're just bringing the whole issue that you've brought to us, all of the statutes that we think pertain to that issue. We're not out asking, did you bring in the garbage? We're saying, here is what you brought to us as an issue, but you failed to address certain aspects of the statute. And so we had a second hearing and gave everybody a chance, and they could have said, that's garbage, and you should have left it out there. And to a certain extent, they probably did. And then we look at that again, and we wrote our opinion, and then they still appealed it to the district court. So it went to the district court and then back up to the Supreme Court. There are always two other checks on anything that we do at the Board of Equalization. And to a great extent, sometimes the second check just doesn't happen. The district court, more often than not, just certifies directly to the Supreme Court because they, they're a little overwhelmed and they don't deal with tax all the time. But I don't think that even we, and I doubt that any future board, just based on the past boards, are really out there trying to reach for ways to get into a taxpayer's pocket that isn't a legitimate question.
Okay, anybody else? Representative Gray.
Thank you, Mr. Chairman. I want to go back to the narrative on the Solvay case because maybe I didn't understand it. And did the State Board of Equalization decide to take up these issues even though they were originally not brought up by either party? And if so, was that decision appealed? Because it sounded like you decided to do it anyway, even though the statute's unclear. It was appealed and the Supreme Court ruled you can do it. That's what I heard when you were describing it. So can you go through the fact pattern again? Because maybe I missed it.
Mr. Vice Chairman.
Mr. Chairman, certainly, Representative Gray. So what happened was the parties came together to talk about a bagging fee and whether it was deductible. But remember that all the deductions are construed under the umbrella of a valuation method. The method sets out several provisions and lots of definitions. We're talking about soda ash or Trona. And so what happens is they're fighting about soda ash and whether the bagging costs are deductible in the valuation. But remember, with Trona, there's this thing called an industry factor. The industry got together with the department and everybody in the legislature, and they came up with this valuation approach that says you get to deduct X percent from your price. As a deduction, you get 70-some% to all of your costs are 70-some% of your profits are not taxed. And so what was happening is they were saying, we're going to, in addition to that, take a bagging deduction. And we looked at this and then went through a hearing. And they talked about this bagging deduction. And when we were looking at it after the hearing, we said, look, the valuation method itself doesn't provide for an additional deduction on top of the industry factor deduction. This is way more than you probably want to know about it. But we said, so we located a language in the statute and two rulings that this board had issued that had addressed this pretty much right on the mark. And we brought the parties back in and we said, here are some additional questions that we would like you to address as part of your advocacy in your positions. And they did. And we said, look at it this way, because of how the method works, here is another issue that you haven't even considered. The department and the taxpayer are fighting about this little deduction. And if they were wrong about what they were not focusing on, there would be no deduction in any event. It was all part of the overall deduction, the industry factor that the legislature had enacted. And we brought them in, let them brief it. We had full briefing and another argument to address that specific additional issue. And then we resolved the case based on that. And we said, there's no deduction period for this. You've already gotten your industry factor valuation, and there's nothing in the statute which says you get to add another deduction. Unfortunately, like I said, if you look at the statutes, there are some leftovers from throughout the decades. And there was one provision in the statute which was, in my mind, ambiguous. The Wyoming Supreme Court disagreed. But in any event, Solvay went to the Wyoming Supreme Court and said, the State Board of Equalization raised this issue that we didn't raise. And the court said, yeah, they can't do that. So they sent it back. They reversed us and sent it back and said, just deal with the deduction as you've argued it. So in effect, the court was saying, even though, notwithstanding whether you're right or wrong, you did not get to look at the statute as a whole. I mean, that's in effect what the court said. The dissent said, no, that's not right. There were two judges at the Wyoming Supreme Court that said, no, that's not right. They are the tax court for the state. They have to be able to look at these issues and address all of the pertinent authority, and they had that authority to do so. So it was a 3-2 split decision. Anyway, the majority though agreed with Solvay. The parties then resolved it, and the department and Solvay went ahead with what they did. And then it came back the next year, because as in any mineral instance, you have the same valuation issues every year. It's there's always a cycle. And the department then valued it consistent with what we had ruled that had been reversed. And there was another appeal, went all the way up to the Wyoming Supreme Court. This time it was teed up with the very adjudication that we had issued. And then the Wyoming Supreme Court ended up affirming what we had done. The department basically had adopted what we said the first time, but in the second run up.
Okay.
That's it.
Anybody else? Take a deep breath. Let's move on and talk about the other bill, okay? And then we'll hear from the public on both bills. So the other bill, which would be
61?
Yeah, 61.
Well, and I'll preface this, Mr. Chairman, by saying, this could have easily been sponsored by the Wyoming Association of County Officials or someone else, but we had been hearing in past testimony before this committee, the frustration of the county boards. And so we took a shot at putting together some language to address something that's been a problem, I think, for some time. County boards of equalization are in kind of a gray area in terms of what they can do. They're not permitted to, in quote, set tax policy. And when we saw rulings from the county boards before us, we saw a lot of rulings in which they were simply remanding for reconsideration or remanding for another look, but with no specifics, nothing that identified what exactly they felt was wrong. And I think the county boards felt like they were in no man's land, because if they did that, they might be accused of overstepping their authority. And assessors were oftentimes arguing, hey, that's my domain. You're not permitted to look at that and or go there. And so it made for a frustrated group of county boards. There's only a handful that really issue decisions that are appealed every year, maybe 4 to 6 or so. But in any event, it was frustrating for them, and it was frustrating for us, I should say, just because when you get a ruling that says, we disagree with the valuation, go back and take another look, and then the assessor might say, oh, I took another look and I'm not going to change it, and then we would be right back to square one with a new appeal. And so what we wanted to do was address the issue head on and just specify, change the statute so that it reads that for purposes of the subsection which addresses not setting tax policy, we wanted to specify that county boards could, based on evidence, identify the problem or the error that they saw, and that would not be violative of the language in the statute which says that they're not permitted to set tax policy. That they are, and then we broke it down into two subsections. They can provide direction on how an assessment should be changed based on the evidence, and that's a critical component here. They can't just say, we think you should do it this way. They've got to say, we think you should do it this way because the evidence was this. And that they could remand on that basis for a correction. And then the second item is to remand the assessment to the county assessor with direction that the county assessor consider specific factors and issue a new assessment or reissue the assessment with an explanation. So really all we're trying to do is pry open this language in the statute and make it a little clear to the county boards as to what they can do so that they don't feel so kind of lost in the dark in this stuff. Because most of these folks come in, they've never participated in an adjudicative proceeding. They don't know the mass appraisal system. These are fairly heady concepts, and we thought they needed to have a little more direction on this. So that's kind of where we ended with this. And I will say, and the county assessors have voiced some opposition to this, and we hope that that they come with an idea of how they would like to see this language changed. And we have been in contact with them, but I have to say at this point, we haven't made any, we haven't bridged the gap on any of their points of contention. So.
Fair enough. Questions for Mr. Herzog? Any questions?
Mr. Chairman.
Representative Sweeney.
Thank you, Mr. Chairman. So I think this is a step in the right direction, in my opinion. And it's not whether anybody in the audience believes it's only a Natrona County issue. I'm here to tell you it's not just a Natrona County issue. It will happen someplace else in the state. But I'm concerned when you're talking about the evidence, how a county board of equalization might portray that. As an example, we believe in Natrona County, which had 2 years ago over 3,000 appeals. And this year, I think 350 or 400, which is why our county commissioners aren't at the table today, is they're in hearings. But the particular point is the differing of LEAs. And in going through the process. So if you have an LEA where there's portions of it in North Casper, and then the other portion is clear at the foothill with much nicer homes, that has been in dispute as a direct example. So our county commissioners, as do I, believe that was incorrect. Is that evidence enough, or did they have to have gone through some appraisal school to basically be qualified to the county assessor and then the State Board of Equalization?
Mr. Vice Chairman Herzog.
Mr. Chairman,
If you can.
Representative Sweeney, I think that goes far beyond what we're trying to address, only because right now, I understand your scenario, and what would happen is the county board would say, well, we don't think the grouping of properties in the LEA makes sense. We want you to go back and take another look. And the county assessor would then file their brief and say, that's not within the purview of the county board. They don't set tax policy. I do. I'm the elected official responsible for forming those. So right now, that would be a legitimate argument to shut down the county board's ruling simply there. And what we're trying to do is make it okay for the county board to say, we don't think that the LEA is constructed properly based on the evidence that we saw. And it empowers the county board to be kind of precise. Here's where we don't like what's going on, without getting basically rebuffed by the statute that raises the question then, well, are you setting tax policy? Because right now, the county board, arguably anyway, might be rebuffed simply by going to the LEA discussion, Representative Sweeney. So this language at least invites the county board into the discussion and allows them to make a point in their ruling and identify what they don't like in the evidence, in terms of what they don't like in the evidence and support of that disagreement. In terms of your specific scenario, I don't know. I mean, there's a whole array of arguments that would go along with whether the LEAs are properly conceived. And that, of course, goes far beyond the point of our discussion here. There are lots of different items that would come into play in that discussion. So,
Okay. Senator James.
Thank you, Mr. Chairman. Do you think if we were to remove the language of presuming the valuation asserted by the county assessor do you think that would kind of put everyone on equal grounds and let the board look at the evidence provided by the taxpayer at a more equal ground?
Mr. Herzog.
Mr. Chairman, Senator James, I don't believe so. In every proceeding, there is a burden put on one party to begin. It's kind of integral to the litigation process. The plaintiff in a civil case has to present evidence in support of their case, and then the defense has to respond with that. And in every governmental setting, or there's at least, usually it's the claimant that has to initially carry their initial burden. In terms of a presumption, I'm not sure that, this doesn't really address that, but I don't believe that would clarify or assist the county boards. They are absolutely benefited by this notion that, look, we've hired or elected an assessor to do a job. They have the expertise. You have to come forward with something that shows that they got it wrong. And if you don't, then the proceeding is over. You haven't carried that initial burden to overcome the presumption in favor of the assessor. So.
Anybody else? Anybody else? How about, I think what we should do, we'll take public comment on both bills. And if you don't need to comment on both bills, please don't. And let's hear from the public in this room. We could start with the department. Would that be appropriate? Nothing? Okay. Can we start with the assessors? Ms. Huxtable, welcome. It's good to see you.
Thank you, Chairman, members of the committee. Dixie Huxtable, Converse County Assessor, and currently serving as the legislative chair for the Wyoming County Assessors Association. And this is just be a little preface for all the bills for today. We have not had a meeting as an association, but we did send out a survey based on all the bills that were going to be discussed today, and took a survey, and I did get back about 18 responses. So that was great out of the 23, considering I only gave about 24 hours to get back to me. So that was really great. In regards to these two bills, the first one about the State Board of Equalization questions, we have no basic position on that bill. That is a tax policy, as was stated before, doesn't really affect us unless we certify a local case to the state board. And so the consensus was no action, no comment on that bill. When we get to the second one, the County Board of Equalization Authority, I have a lot of comments on that bill and no support for that bill. There's a lot of no action or no support. We ask when we do these surveys to we give them three options: support, no support, or take no action, basically a tax policy, and then of course to offer comments. So the general concern with this bill, let me start with the last page of that bill we have no problem with. The second part of that, where we have to address or give a reason why we didn't consider a specific factor, there is agreement that that should already be happening. So if it needs to be in statute to make sure it is happening, we really had no problem with that, that bill, that portion of the bill. The part that we did have concern about was the remanding back and giving direct direction to the county, to the assessor on what to do with that value. And bottom line, that is the concern. Would this language allow the county board to say, for example, I saw this appraisal, this fee appraisal come in as evidence. It was presented. We like that value better. We're going to remand this back to you, consider that evidence and change the value. That's a concern. Every assessor is required to have education. We have to have training, and we are doing mass appraisal. Many times, a lot of the people in these hearings don't truly understand a mass appraisal, including those members sitting as the County Board of Equalization. There is a learning curve to understand that. To my knowledge, we've never disallowed evidence. They are allowed to present any evidence at those hearings that they feel is appropriate for their case. How the County Board of Equalization interprets that and transfers that into findings of fact and an order is somewhat out of our hands. We can only offer the evidence that we have, but the County Board of Equalization makes their own rulings. We really would be concerned if the language in this bill was to allow that county board to go back and set the value based on a piece of evidence. Remanding it back to us to consider and expecting us to give an answer, we absolutely agree with that. I would be somewhat concerned with county boards of equalization members understanding all the valuation methodology in the first try. And this language says that if there's evidence of incorrectly or inappropriate applied methodology, they can remand it back to us. There's some concerns about how are we going to educate that County Board of Equalization to understand all that. We do our best as assessors in a hearing, but that's not always a guarantee. So the bottom line, there was a lot of comments about it. There was a lot of comments from our assessors. If there really is that grave of a concern about it, maybe we need to be considering moving outside the realm of the elected county commission board. Maybe it's time to look at a regional board where there is no pressure on the side of that board to make decisions. If any of you have said in those hearings, you know that that is local people serving as the Board of Equalization, and their friends and neighbors are a lot of times those that are coming forward. And it really does put considerable pressure on those members to be able to understand what's being said and make a fair and equitable decision that's within their realm and their responsibility. So some of the assessors felt like maybe we should look at that. It's been brought up before, many years ago. But we just really do have issues with this language. If it was to go to the level where they could set the value based on the evidence that they were given. If maybe some language was that they could provide direction on how the assessment should be changed based on the evidence of incorrectly applied methodology, at least you're directing it to a specific piece of evidence that was found during the hearing that said the assessor didn't apply this methodology correctly. We're going to remand it back to you and you need to look at that specific thing. But to leave it broad that they could just set the value would be a concern for the assessors. And I would stand for any questions.
Okay, we've got Representative Gray. Anybody else? Representative Gray.
Thank you, Mr. Chairman. And I'm curious as to what the Assessors Association position is on the objective of county boards of equalization. I mean, what does the association view as the point? Because if they cannot set a value, then I just don't understand why we're doing this. I mean, it's very time consuming. And you can still appeal, even with the statute, you can still appeal to the State Board of Equalization, which is a constitutional structure and also one that is laid out in state statutes. So, I mean, I think this is addressing the concern of the counties look at these cases and they get remanded to an assessor and the assessor doesn't do anything with 97% of them, where they've taken months and months, hours, thousands of hours into these hearings. So I guess my question is, one, how would you respond to that? And two, what is the assessor's view on what's the point of the county? What is your view on what is the objective of the County Board of Equalization? Because if they can't set an assessment level, I don't understand what they don't view their time as being well. There's really nothing they can do.
Ms.
Mr. Chairman,
Huxtable.
Representative Gray. So a very good question. We really have no problem with the County Board of Equalization, the members, but they have not the training and the education and the experience in the mass appraisal world that the assessors are required to have. So that is primarily the biggest concern. is that you would be shifting the responsibility of setting a value that we have to follow and be statutorily compliant with all of our statistical analysis. And you have individuals doing it that have no training, no education, no experience. The purpose in my mind, I've never posed this question exactly to our board, our association, but the purpose of the County Board of Equalization hearing is to give the taxpayer the right to question their values. That's presuming that they've already went through a review period, because that's also in the statute, that they have the right to have a review with the county assessor, and that they've come to a point where they have irreconcilable differences on the value. And then the opportunity is there for the taxpayer and the assessor to present their case. And for my personal perspective, and I can't speak for the other assessors because I don't sit through their hearings, but we go into those hearings as if there is no presumption of proof. We start with the fact that this is how we valued it from the ground up, and this is how we got there. Now, I cannot speak to every assessor because, like I said, I don't sit in on those hearings, but that is how we're trained. That is the education we're given to do. And then the taxpayer has the same opportunity. And many times the evidence that gets shared during the discovery process of a county board hearing gives us evidence that we didn't have. We didn't have access to their house. We weren't allowed in their house. They've now given us a fee appraisal where they did allow somebody in the house. We got more data. We got more correct characteristics. We can update our system correctly. And many times that's why the cases don't go to full hearing. We went through a formal appeal process and did discovery, but we got information that we didn't have before. The other cases is the opportunity for the taxpayer, quite honestly, to vent in some cases. They don't have a problem with the value in many of our cases. It's not the value they have the problem with, it's the percent increase. When the question is asked, do you believe that your property is worth that on the open market? That's not the issue. The issue is, I don't want this increase, and my neighbor didn't go up that much, so how can I go up that much? So the purpose of the hearing is to get all the facts out, at least in my opinion, get all the records corrected, and give that taxpayer an opportunity to present their case. That's why many of them do go onto the state board.
Okay, anybody else? Let's do Representative Sweeney. I'm mindful of the time. I'm just throwing it out there. We got a big lift and it's going to go tonight. So be careful what you ask for. Representative Sweeney.
Thank you, Mr. Chairman. So I'm sure I'll offend quite a few people, but our County Board of Equalization has been through a number of hearings. I would agree with you to a certain extent if you have a new county commissioner that hasn't gone through, but I think our county commissioners, current county commissioners, are far from a board of bumbling fools. And I think they have been through enough training to understand the LEAs, differences there. I don't think they're trying to set valuation, but they see their only choice is to try to remand it back to our county assessor, who in turn says, it is what it is. He has taken a better position, in my opinion, this go around, and has gone and relooked at some things. But for the future, I think the county assessors should recognize the county board needs some sense of authority. They're not trying to, of course they've got neighbors, but I don't believe they're necessarily trying to be unjust or unfair. But I believe they need to have something Whether the county assessors, obviously, you're not going to agree. If you've got 18 that said no, but I think we need to do something.
Okay, Ms. Huxtable.
Um,
I guess there was a question in there. What do you think it was?
Mr. Chairman, I'm not sure what the question really was, except that, let me answer it. This is that I have the utmost respect for the commissioners in every county. If they didn't know when they signed up, they know really quick what they got shortly after they got the oath of office. And it is a daunting task to be a county commissioner. And I have the utmost respect for them. But there is no way that they can know all that there is involved with LEAs, neighborhoods, stratification, income approach, cash approach, without some educational experience behind them. That's just a lot of education. The assessors are required to have a fundamental class plus 90 hours of core education. So it would be a lot to ask a county commissioner to understand. And it's not just as simple as saying, I think this house is in the wrong LEA. There's a lot more that should be explained in that whole scenario. If it was not, then there is the right for the county board to ask for those questions. So while I have a lot of respect for them, I know it puts them in a difficult position sometimes, one, because of who the taxpayer is, but also because maybe they don't fully understand the process. And asking us to explain, giving us a remand back to the assessor with a selective factor or a specific factor you need to concern, absolutely should be done. And the assessor should respond. The assessor should be able to explain why they didn't consider that. Or I considered it, but it didn't fit this property because. That should already be happened. And that's part of this bill that we absolutely do support. And whatever language that you guys come up with this bill, I would just caution you that if you are allowing a board of commissioners to set the value for a variety of properties in their county, I would suspect, you're right, there's going to be appeal processes go up the ladder. And that would be the opportunity for the assessors to move on up to the state board for an appeal. And I would anticipate that would be happening.
Anybody else? Let's take another shot at this. So Ms. Huxtable, thank you very much. Anybody else want to testify on this bill, either one of the two bills? Mr. Riemann. We have two bills up. Are you going to testify on both or you explain it? Okay.
Good afternoon, Mr. Chairman, members of the committee. I'm Jeremiah Riemann here on behalf of the Wyoming County Commissioners Association, which, as you know, is also the County Board of Equalization.
Association.
Right. And thankfully not the Band of Bumbling Fools Association. Mr. Chairman, first off, I want to say that as I discussed this piece of legislation with commissioners almost to a person, they indicated that they certainly value the work that the assessors are doing across the state and really do think that they're bringing forth good work. Unfortunately, and we've had that happen in the course of the past few years, and to Representative Sweeney's position earlier, it has happened on other occasions where we've had issues in this state that have caused the commissioners a great deal of heartache and heartburn relative to assessments and issues as the County Board of Equalization. If you think about the commissioners and look at the existing state statutes, really could look at them as a bunch of individuals that frankly are in front of the firing squad. We've got the assessor with a presumption that they're right. You have a number of people that are frustrated with the issue. And frankly, the commissioners often are frustrated with issues that go up to the state board and just get pushed back down without resolving issues and giving them a sense of where to go. Commissioners, in looking at this bill, do support the second portion that's on page 3. There has to be a system by which the county assessor is giving the public, giving the board itself some sort of answer around these issues. And unfortunately, in Natrona County, there have been a lot of instances where the same decision comes back and there's no explanation for why that decision is coming forward. So we certainly support that. Commissioners are supportive of doing something different. I couldn't get them to commit that the exact language in here quite gets them to the place that they want to be, because it really didn't answer the question and give them really any more power other than to say we can remand back to the assessors and tell them how to do their job. I think the commissioners want to do their job, and that is to review these things, and if appropriate, and this goes to Representative Gray's question earlier, what's the purpose? If appropriate, they want to be able to provide relief. Mr. Chairman, I tried to think about this and come up with something to bring forward to you. I have nothing perfected, but I went and looked at what other states have in this particular space. What is the statutory language give their boards of equalization? So I looked at Colorado. It says this: the County Board of Equalization, it shall correct any errors made by the assessor, and whenever in its judgment justice and right so require, it shall raise, lower, or adjust any evaluation for assessment appearing in the assessment roll to the end that all valuations for assessment of property are just and equalized within the county. I think that's what we're all seeking here is just and equalized within the county. What's Idaho say? It says this: it is hereby made that the duty of the Board of Equalization is to enforce and compel a proper classification and assessment of all property required under the provisions of this title to be entered on the property rolls, and in doing so, the Board of Equalization shall examine the rolls and shall raise or cause to be raised or lower or cause to be lowered the assessment of any property which in the judgment of the board has not been properly assessed. How about South Dakota? It says a county board of equalization may correct clerical errors of the assessment roll. 2, hear appeals from individuals regarding aggregate assessments, classification, and equalization. And number 3, equalize between taxing districts and between classes of property. The board shall raise or lower, if necessary, each class of property on a percentage basis covering the class as a whole within the assessment district. All of them, as you heard, have the County Board of Equalization having the ability to raise or lower assessments as needed. And you do not find that language in Wyoming state statute. It simply says we have no power to set policy and I'll forget the other language there. With that, Mr. Chairman, I'm happy to stand for questions, but certainly I think the commissioners are looking for a bit more clarity and context as to what their powers are, rather than just being the individuals before that firing squad.
Okay, who wants to go before the firing squad here? Questions for Mr. Reamick? Representative Gray.
Thank you, Mr. Chairman. Could you send those 3 examples to us? Thank you.
Yeah, thank you. Who else? Mr. Co-Chairman.
Mr. Chairman, the training that assessors go through, and you won't have this answer, but I want to throw it out there. I'm just wondering how, if we're going to take on this new role, education will be the key of some, the local board, I think. Anyway, that's for farther down the road, but it's a thought I have.
Any other questions for Mr. Reamick? Representative Sweeney.
Thank you, Mr. Chairman. So you only indicated on page 3, which would be Romanet II. So on page 2, you found, your association found no value starting on line 6, all the way down at the bottom of the page in those points.
Mr. Reamick.
Mr. Chairman, Representative Sweeney, I don't want to suggest that there's no value. I think that the commissioners didn't have the sense that the language quite got them to the place that they felt they wanted to get to relative to this. This has a lot of remanding back. And I think what commissioners have looked at it is that they are one layer in the adjudicatory body. They are a decision-making body. They should be able to make decisions. If it needs to be appealed, it goes to the next level of adjudication, which is at the State Board of Equalization. A lot of what this language says, again, is we just remand it back. We end up with the same decision in a lot of instances. We are in that cycle that commissioners really want to get out of.
Anybody else? Representative Gray, another bite at the apple.
Thank you, Mr. Chairman. So your issue with page 2 is that, just from the language you were wanting us to move more in the direction of, is that you don't think that gives the county boards the ability to set a value? I think it does, but is that my understanding your concern right, that it doesn't do enough?
Are you referring to lines 18 through 21? Yes. That's what I think. Back to you, Mr. Reaman.
Mr. Chairman, Representative Gray, I don't know that it's limiting them in terms of the decisions. It just isn't sort of the structure that they are really interested in relative to what they would like to move forward with. As it says, let me just get to this. May either affirm or reverse and remand the assessment. The board can then go to, remand the assessment is down on line 20. So it's all going back to the assessor. And what I'm hearing from the commissioners, including commissioners in your neighborhood, is they're tired of sending stuff back to the assessor to get the same decision that they've been getting. They would prefer to make the decision and have it move forward.
Okay. Anybody else? All right. Thank you, Mr. Reaman. Thank you very much. Who else would like to address the committee on either of these two bills? Who else would like to address the committee on either of these two bills? Not seeing anybody. Is there anybody online? Two bills on the table. Committee, what's your pleasure? Let's decide taking up 23 LSO 60 first, Board of Equalization, questions before the board. What's your pleasure? Got a motion by Henderson. Is there a second? Got a second by Baker. Discussion on the bill. Any? No, we're doing 60 first. We got to take one ahead of the other. 60 is the first one that the board can suggest new questions for the litigants to address. Okay? Everybody clear that we got the right one? And I know it's confusing taking two bills up at the same time, but it seemed efficient at the time. Okay, so Emily, could you call the roll on 23 LSO 0060?
Senator Baldwin. Aye. Senator James. No. Senator Pappas.
Aye.
Senator Schuler. Aye. Representative Baker.
Aye.
Representative Gray. No. Representative Hallinan. Aye. Representative Henderson.
Aye.
Representative Jennings. No. Representative Roscoe.
Aye.
Representative Sweeney.
Aye.
Representative Yin.
Aye.
Co-Chairman Harshman.
Aye.
Chairman Case.
Aye.
That passes.
Thank you very much, Emily. So the next bill for our consideration is 23 LSO 61. It's the one we were just having the most recent discussions about, the powers of the County Board of Equalization, their authority. So we've got a motion by Sweeney. Is there a second? Second by Gray. Discussion. The amendments, Representative Gray. I'm not sure why not. Mr. Co-Chairman?
Okay, are you taking amendments?
Well, you were weighing in on that, so.
No, I was gonna make an amendment, but. I
Okay,
didn't know
let's
whatever you
hear what your amendment is. He can work on his. Go ahead, make your amendment. Mr. Co-Chairman.
Mr. Chairman, it'd be on line 11, page 2.
Okay,
Starting at the end of the line where it says in, and I'd like to just delete in a contested case, the County Board of Equalization may determine whether the county assessors correctly applied evaluation methodology and may either affirm or reverse and remand the assessment, period. Just like to delete that sentence.
so that, just to be clear, well, why don't we find out if we've got a second first? Who was the second? Again, so now the entire new language is going to say, for purpose of this subsection, a decision or order by the County Board of Equalization that directs the county assessor to revise an assessment based upon evidence received by the county board at a contested case hearing shall not be considered setting tax policy or engaging in the administrative duties of the county assessor. And the next sentence is gone. It says if, and it ends with, if the County Board of Equalization reverses an assessment, the county board may, and it goes into the next little section. Discussion on the amendment. How about from the state board?
Mr. Chairman, yeah.
Go ahead.
No,
Just give your
go ahead.
justification.
No, go ahead. I just don't think the sentence is necessary. And I think it works without it, frankly. I don't think it's necessary.
You don't think it's serving a prescriptive purpose?
I don't think so.
Okay. Mr. Herzog, what does the board think? Is your microphone on? Make sure it is. It's,
Mr. Chairman, Mr. Co-Chairman, it may be superfluous. It was a point just to really clarify, an argument that's been made so many times, but I suppose it flows okay without it. The preceding sentence seems to say that as well, maybe in general terms.
okay. Any further discussion? Representative Gray.
Thank you,
On this
Mr. Chair.
amendment?
I mean, I think that considering the last bill was clarifying something that I think it's important to be clear. And what I like about it is it sets out the two options very clearly. Either they affirm or they reverse and remand. And it reads nicely with the next sentence, because then it says, if they reverse and remand, I like it. I don't totally understand what the objective is, and I think it's a little bit less clear if it's not in there.
So you're advocating a no on the
Yeah, I'm
motion.
advocating, Thanks.
Further discussion on the amendment? Further discussion on the
Mr.
amendment?
Chairman.
Go ahead, Mr.
Yeah,
Co-Chair.
I just think that, you're dealing with elected officials on both sides, and I just don't think the County Board of Equalization, I mean, when you read that sentence, now the county assessor is basically on trial, and the county board is gonna, I don't know if it's the county board who's not necessarily been trained in the same processes as the assessor qualified to do that, to say that in that sentence. And I can go along with Romanet 1 and 2, or I and Romanets 1 and 2 following that, but that really takes care of the issue. But I think that sentence goes a little far, I think.
Okay, Mr. Vice Chairman Herzog.
Mr. Chairman, Mr. Co-Chairman, just to give you a little more context, if you go to the end, you'll see that very same language in 109, which is the appeal process. And that language, basically that last two sentences, the County Board of Equalization may affirm the assessor's evaluation or find in favor of the taxpayer and remand the case back to the assessor. And then we added the reference to that statute that we were just talking about, as provided in Wyoming Statute 39-13-102D. So it is already in the statutes. And so it's in the preceding provision just to kind of parallel that provision. So if you did take it out, I think it's already there. It's just, like I said, it may be extra, and you could get away with taking it out because it already is in 109. Does that make sense?
I think it does.
Mr. Chairman.
I think you say the amendment's okay. Mr. Co-Chairman.
Yeah, the amendment, I think because that last language in 109 says affirm, it doesn't say about whether the county assessor is correctly applied. That's a different kind of sentence, and it's not really exactly repeated later on like that. So I just don't think it needs to be in there. Thank you.
Okay, any further discussion? Any further discussion? Ready for the question? Question is on Mr. Co-Chairman's motion to delete that sentence. I've slipped in my efforts here. And the sentence is, in a contested case, the County Board of Equalization may determine whether the county assessor has correctly applied evaluation methodology and may either affirm or reverse and remand the assessment. The motion is to remove that sentence. All in favor, say aye.
Aye.
Any opposed, say no.
No.
I'm a little bit unsure. Let's have the ayes raise their hands. Got Dr. Hallinan, you're just adjusting your glasses, weren't you? Okay, we've got one coming down this way. Hope you pick up some more. 2, 3, 4, 5. Okay? Okay, and all those opposed to that, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8. Did you have 6 before? Well, you got 8 now, so you still lost, okay? It's tough out here in litigation land. All right, any further motions? Did you come up with a motion, Representative Gray?
Thank you. Mr. Chairman, I would like to, my motion is to delete on page 2, line 15, the words "and remand."
Okay.
And then on page 2, line 18, I would like to replace lines 18 through 21 with the language that was laid out by Mr. Ryman, which is modeled after the County Board of Equalizations in Colorado, which is correct any errors made by the assessor, and whenever in its judgment justice and right so require, it shall raise, lower, or adjust any valuation for assessment appearing in the assessment roll to the end that all valuations for assessment of property are just and equalized within the county.
You have that written out? Mr. Representative Gray, you have it written out?
I do, yeah.
Can you share it with the Board of Equalization so they can weigh in? And we can share it with the counties. I mean, the county assessors, with counties of it. Yep. We have not. Okay, so we got it shared. Is there a second for the motion? Second by Sweeney. Discussion? You guys, how about the assessors? Have you seen it? You want to look at it? How about sitting down and grabbing a microphone? You'll be all right. Up here. Can you share the language with Assessor Huxtable?
Okay, so, Mr. Chairman, can I repeat the language?
Yes, you can.
Okay. Correct any errors, this will be a new Romanet, and we're deleting the other one, Romanet 1. Correct, and we're replacing with correct any errors made by the assessor, and whenever in its judgment, justice, and rights so require, it shall adjust any valuation for assessment appearing in the assessment roll to the end that all valuations for assessment of property are just and equalized within the county.
Assessor Huxtable?
Mr. Chairman, I guess I would have to review that a little bit. I know that there are some more, I believe there are more steps in Colorado to go through the appeal process, but I don't know them off the top of my head. Whether this is the language for the final decision or the intermediate, I don't know where this falls in there. And I guess the concern when you're talking about that all valuations are just and equalized within the county. So if you change one property, for example, because of an LEA or a neighborhood, does that mean you're going in and equalizing all of them accordingly? Is that what this is saying? Is that you found an error, so we're going to go back and change all of the county that's related to that? I think that we just have some more questions about that, and mostly because we just hadn't seen the language, sir.
Yeah, so it's, so fair to say that you're not supporting it at this time?
Correct, sir.
Okay, fair enough. Any other questions, discussion? Anybody else in the public want to weigh in on that question? Okay, committee, you ready for the Mr. Assessor Meyer? Yeah. Let's hear from Assessor Meyer, and you can ask whatever you want. Assessor Meyer, please.
Mr. Chairman, members of the committee, that sounds to me like equalization's going on that amendment, the county board. That means the county board has the ability to go in and equalize your county. If you're undervaluing everybody or overvaluing everybody, they could do it. It's never been done, ever. So the state board's only done it once. So that probably isn't gonna happen. It just seems to me what everybody wants here is either you win or you lose. That's as simple as that, you know? If it's a valuation question, if the assessor says it's 400,000 and you show it's 350,000, they want you to set that value down to 350,000, you win. And the assessor can still appeal that if he really believes he has the right. But that's what I think everybody wants. They just don't want it remanded back and for the assessor to do nothing because he figures he's got it right. That is the problem. The solution, in my opinion, is you start looking into other boards that know the valuation process. Montana, they hire appraisers, real estate people, bankers, people who know what's going on in your community on the valuation process. The county commissioners, they don't know. They're not realtors. They're not appraisers or bankers in most cases. So they have a hard time trying to decide who is right. But I believe if you come in with even a fee appraisal and it's good, we might not be able to use it, but it's got an indication of value, a county board or people who know the valuation process should be able to put it to what it was. And that's just my opinion. So there you go.
And to be clear, you're speaking against Gray's motion? Representative Gray's motion?
Yeah, because I think that I am speaking against that because that's an
currently
equalization.
drafted.
That's an equalization process, and that opens up a whole can of worms that the county commissioners wouldn't even know where to
Fair enough.
start with that.
Thank you. Questions for Mr. Meyer? Thank you.
Mr.
Hold on, we got Mr. Co-Chairman wants to.
I just would like you to stay right there for the next amendment, because I'm gonna draw on I have a question for you after this amendment.
Okay, and Representative Gray.
Mr. Chairman, so the second half of that amendment did something that I did not intend to do. So that's leading to a lot of the discussion. So I want to amend the amendment, and maybe then the seconder can affirm whether that's fine or not.
Can you just withdraw and get your second to agree with you and then redo it?
Sure,
Might be cleaner.
I'm fine withdrawing.
You ready to withdraw?
Yeah.
Okay, start over
Okay.
again.
Mr. Chairman, so the amendment on page 2, line 15, would delete the words "and remand." And then it would delete on page 3, lines 1 through 5. Excuse me, never mind on that, because we still want to provide the option for them to remand if they want to. And then, so forget, no changes on page 3. Page 2, line 15, delete the words "and remand." And then page 2, line 18, we just say correct any errors made by the assessor. And if anybody has a suggestion, and the rest is deleted. So they have two options there. One is to remand it, that's on page 3, and then the second is just to correct it. And then the process ends and the assessor can appeal it. And I think that should be pretty clean.
So just to be clear, we haven't got a second yet. Your motion is to, on page 2, line 15, strike the words "and remand."
Yeah.
And then coming down to lines 18 through 21, you want to insert the words to have the should be changed to correct the assessment?
Correct any errors made by the assessor. And that'll be Romanet 1, just correct any errors made by the assessor. It may need some cleaning up, we can do it in the session. And then option 2, which is not changed in the amendment at all, is they can still remand it. And that, I doubt they'll exercise that often, but they
Let's see if you
could.
get a second. Okay, got a second. Discussion. You're sitting there, you might as well address it.
Mr. Chairman. Correcting the errors, that kind of opens up, how do they have the education to know if it was an error? Is an error because we feel you have the wrong condition on it, for one thing? I mean, we say it's in fair condition and you have it in good. I mean, is that an error? That's a judgment call on the appraiser's part, an educated judgment. And you want to do it uniformly. You're always looking for the uniformity. If these are in good condition, all those kind of houses are in good condition, but it goes even with an appraiser. It could go average, could go fair.
I think you made your point.
Okay, thank you,
Thanks.
Mr. Chairman.
All right, Representative Gray.
Mr. Chairman, Mr. Meyer, you just testified that what we're trying to do is to say that they can correct it on their own, okay? And then you can appeal it. You seem to say that you were possibly fine with that, even though maybe the board isn't, or the other assessors. So what would be your suggestion for language? Because all I'm trying to do is to give the county board the option to correct in that one case. I'm not saying to equalize across the board, but in that one case, and then you can appeal, the assessors can appeal. I'm just trying to do what you suggested a few moments ago.
Oh, now just a little bit of a timeout here. The word correct is kind of pejorative in this context, I think. I just don't think it's, I'm not sure that it's the right thing to say, we're going to correct it. So I'm not sure what's wrong with this, but I don't understand, and you certainly can answer the question that Representative Gray is talking about, but it does sound pejorative to me. Let's hear what you have to say.
Mr. Chairman, all I want is if you've proven your case and that value should be 300,000 and not 400,000, I don't really care what error you made. It goes to that. If the assessor doesn't like it or hasn't won or didn't have enough stuff to overrule, to defend his value, well, then we should put it at that value. And if you want, you can put it up. It all changes the next year. You all go back to start, right? You have to come in, appraise the whole thing all over again and appeal it all over again. That's the process we have. So if that value is incorrect, I see no reason why an educated board, not the county commissioners, people who understand the valuation process, again, I'm talking states like Montana, the county commissioners appoint the board to hear the hearings. The governor appoints the state board or the above board to do that. The state board equalization doesn't even hear the hearings.
Assessor Meyer, can we just focus on this?
Okay.
I'm really sorry, but.
Okay, well, back to Mr. Gray's question, Mr. Chairman. I don't think the board should be allowed to, well, for argumentative purposes, I don't have a problem with the board saying there's an error, because then you can still appeal that to the state board.
Okay.
So if that's how it goes, I would have to concede to that.
Okay, thank you. Any further discussion? Anybody else want to weigh in? Everybody wants to go home. That's what I want to do. Okay, ready for the question on Representative Gray's amended? And just read it out one more time.
Okay, so the amendment on page 2, line 15, is to delete the words "and remand," and then page 2, line 18, delete lines 18 through 21 and replace it with a new Romanet 1 reading "correct any errors made by the assessor." So what this does is the county boards will have two options, and one is to remand it, and the second is to correct it on its own, which, from Mr. Ryman's testimony is what the counties, I think, want. And you look at this language from other states, it's more aligned with that. And then the assessors can appeal that to the State Board of Equalization. So, in terms of the pejorative aspect, look, maybe the language could be improved for the session, but, I can't fashion it in this moment. So, I think the point is that what we're trying to do is change the language so that the assessors can make a correction on their own without remanding it if they choose to, which as the bill currently reads, the counties appear to think that it does not give them that power, even to make the change. And in both situations, they have to remand it. So that's
Okay.
the intent.
All right, further discussion. Representative or Senator Schuler.
Thank you, Mr. Chairman. Just wanted to offer maybe a friendly amendment to the amendment. Just where you have the correct any errors made by the assessor. Would you be okay with address any potential errors made by the assessor? Would that be a friendly amendment?
Is that friendly? Okay, so that's the new motion. Okay. Further discussion? Further discussion? Josh, you think you got it? Thank you, Josh. Let's have all those in favor of the amendment as friendly amended by our good Senator Schuler signify by saying aye.
Aye.
Opposed, no? No. Let's have a show of hands. All those in favor, raise your hand. Got 1, 2, 3, 4, 5, 6, 7, 8. That's in the majority, so that's carried. Back on the bill. Anything else on the bill? You had something you wanted to ask Assessor Meyer?
Well, no, after this amendment.
That was the amendment. We just finished it.
I thought that was an amendment to the amendment. But, okay, I'm fine with that. Okay, my next question then is, Assessor, can you just tell us the training real quick? So a newly elected assessor, or do all assessors go through certain training every year after every election? Mass appraisal, all that?
Right, so like I have 1,800 hours of education in the appraisal assessment world, but I've been doing it for 37 years. When you start, everybody to be temporary certified has to pass 101, then you're taking 3 other courses, all from IAAO, International Association of Assessing Officers.
Okay,
Very
so let
tough.
me just interrupt. So every assessor
You guys
has
can
to.
go through the chair.
I'm sorry, Mr.
That'd be
Chairman.
a good idea.
Mr.
Thanks.
Chairman, my apologies. Mr. Chairman, so every assessor has to go through that?
Yes.
Mr.
and
Meyer?
Mr. Chairman, Mr. Chairman and Mr. Chairman. Anyways, yes, every assessor, and you have 4 years to get permanently certified if you're an assessor. So it's tough. I mean, I just had to let one of my employees go. He couldn't pass that 101. Fairly smart person, but couldn't pass it. You can't really work in my office because I make everybody become a certified appraiser.
Okay, so Mr.
Go ahead.
Mr. Chairman, so let me narrow this. So do the elected assessors in each county, is it somehow required to go through this training, or do they do it?
Yes.
They're required by
It's
state law?
required by law.
Assessor Meyer, to you.
Mr. Chairman and Representative Harshman, it's a requirement, it's a law. Every assessor has to do that. You have to become permanently certified, and you have 4 years to get permanently certified. And that's in the law. And you have to take 28 hours every other year of education, continually.
Okay, Mr. Chairman, would it
Go
be, I mean, I got this amendment written down that would require the county board to go through this same training. So the 3 or 5 members of the county board then would, at least you're all kind of coming from the same background. Thoughts on that?
Assessor Meyer.
Mr. Chairman, yes, and there are tutorials to teach county boards what their duty are as a county board of equalization. I give one for new county commissioners when we have appeals every year. I took it from Tom Roberts, a former member of the State Board of Equalization, and I added to it. I have shared that with the State Board of Equalization, and at one point they were trying to get all the county commissioners together and teach them this is probably where the hard thing is. I think in your counties, if you take the time with them, you sit them down with just the 5 where they can ask you questions, and you show them the requirements you have to be in compliance with the State Board of Equalization and the Department of Revenue. That gives them an education on statistics, on appraisal. I mean, what their duties are, what you can do and what you can't do. That to me is the answer, but I haven't seen very many counties. I'm sure there are counties out there that do this. I mean, I've done it for years.
Mr. Chairman, so.
Mr. Co-Chairman.
So I guess here's my rub on this bill is you've got duly elected officials and we're saying, okay, we've had this really anomaly with COVID, with all the real estate refugees coming here, and it's just gone crazy. And we have really a pretty incredibly sound system in this state. It really is. And I'm trying to find a way we don't start discarding that because we've had a crazy anomaly. And then I don't want to give 3 or 5 guys who don't have the same background and training sit in there and say, yeah, you messed up, you made a mistake. And I don't know if we know the unforeseen consequence. So I guess my amendment, Mr. Chairman, I'll stop this, but I think that it would be on line 6 on that page 2, and it would say, for the purposes of this subsection, comma, after receiving standardized training from the assessor, period. And then it would continue on. So I'd like to insert that.
Is there a second? Is there a second?
Second.
Got a second by Henderson. Discussion.
Mr. Chairman, kind of already discussed it, but I just think more education for elected officials on this very important topic is not a bad thing. And I think if just put yourself in that situation. You're an expert and you've got 3 other equally elected folks that ran in the same election. Now I'm going to tell you, you're not an expert. You're duly elected too. And I just think there's a problem with this whole you got to kind of equalize the education if we're going to, make an unequal power distribution in this thing. I get it. It's not a perfect system, but I don't know if this is the answer.
Mr. Chairman.
Further discussion, Representative Sweeting.
Thank you, Mr. Chairman. So you've got a freshly minted county assessor who has 0 training. And I think they've got 18 months on 101, if I'm thinking correctly. And then 4 years to get the certification. I don't think it's our business to be putting into state statute what the county commissioners should or should not do in this case. I understand the quandary, but it's happening now. So I speak against the amendment.
Anybody else want to speak on the amendment? Representative Jennings.
Yeah, I have a question for the bringer, Mr. Chairman. So,
Go ahead.
I think piling on to that, you're asking if we adopt this amendment, we're going to make every county commissioner across this state educated just like every county assessor. And so it seems like that might be kind of an overkill to this problem. Now, if we pass acquisition study bill later on, just thought I'd throw that.
See if we get there. If we,
Should
might
we
be
get
midnight.
Mr. Chairman, if I just weigh in for 1 second.
I don't think so.
The State Board of Equalization should be the educators of the county commissioners. They should be given the presentation that I give them. It was theirs to begin with. That's where it belongs. They're the ones who should show the County Board of Equalization and explain their jobs to them.
Thank you.
You're
How
welcome.
about going and sitting down back there? You're not at the table with us right now. So do you want to change it to be the state board?
No, Mr. Chairman, I think I know how this is going to go down. I can sense it, but I think, Mr. Chairman, and then I'll just call for the question on it. But the requirement is not to have the exact same training as the assessor. I think it's to have at least a minimal part of this, and that can be developed through the county commissioners and the state board, but, you know, I think we're gonna give them oversight. And finally, for the state to tell those officials in counties, the counties are the state. We do it all the time. And so that's not unusual. So,
Thank you.
thank you, Mr.
Mr. Meyer, you're dismissed from the witness stand. Would you go back? Thanks, appreciate it. Okay. Ready for the question on the amendment? Okay, all those in favor signify by saying aye.
Aye.
Opposed, no?
No.
I think that failed. You want to call for a division? Okay, back on the bill. Is there any questions on the bill? Anything else? Any other motions? Emily, would you like to call the roll on 61?
Senator Baldwin? No. Senator James? Senator Pappas?
Aye.
Senator Schuler? No. Representative Baker? No. Representative Gray?
Aye.
Representative Hallinan?
Aye.
Representative Henderson?
No.
Representative Jennings? Representative Roscoe?
No.
Representative Sweeney?
Aye.
Representative Ian?
No.
Co-Chairman Harshman? Chairman Case?
No.
That does not pass, Mr. Chairman.
Okay, let's take a 10-minute break and come back and finish off. So we'll come back at 5:20. Don't make us later. What page is it in our packet? Because we got that long report. Here it is. All right, it's 5:20. Let's please come to order. Everybody will go back up and pick up our property tax relief bill drafts. We've got 23 LSO 32. We need to go through the draft first. Josh, want to give us a quick overview?
Sure. Mr. Chairman, Josh Anderson, LSO. So 23 LSO 32, you may recall we looked at this at the September meeting. This was one of the recommendations that came out of the property tax working group. And this would be a constitutional amendment that would primarily create a fourth class of property that would be residential real property. So currently there's 3 classes of property, which are minerals, industrial property, and then all other properties. So this would add that 4th class, which would be residential real property. And then it would also, Mr. Chairman, on page 3, subsection C, it would allow the legislature to create a subclass of residential real property for primary homeowners and allow the legislature to authorize exemptions that apply to primary homeowners or other subclasses of residential real property as determined by the legislature. That's essentially the bill, Mr. Chairman. It was tabled by this committee at the last meeting to this meeting.
Thank you, Josh. Thank you very much. Questions for Mr. Anderson? Any questions for Mr. Anderson? Representative Yin.
Mr. Chairman, thank you. Mr. Anderson, would you be able to explain the little ambiguity, I think, that I emailed you about and what the possible fix for that could be?
Sure.
What's ambiguous?
Mr. Chairman, so on page 3, lines 10 and 11, so the intent there was to say that residential property, so currently all other property class cannot be more than 40% or 4 percentage points more than, industrial property cannot be more than 40% higher or 4% higher than all other property class. The intent there was to also make that apply to this new class of property so that neither of them could be more than 4 percentage points different from industrial property. The question was whether that should be an or there on line 10 or an and or some different thing. When I spoke with Representative Yin about this, I believe the solution was to say, to just restate it. And so it would say not more than 40% or 4 percentage points more than residential property or more than 40% or 4 percentage points more than all other property. So to restate it to make it clear that that applies to both classes.
I think that would make sense. Thank you for catching on that. Any other questions for Mr. Anderson? Any other questions for Mr. Anderson? Representative Yin, do you have that amendment? You'll offer it at the proper time? Thank you. Thank you, Mr. Anderson. Who would like to address the committee on this bill? Anybody like to address the committee on this proposed resolution? Are you trying to get our attention, Mr. Raymond, or, okay. Is there anybody online that would like to address us on this proposed bill?
Yes, Mr. Chairman, we have Brett Moline.
Let's hear from Mr. Moline. Is he the only one, Emily? Okay. Mr. Moline, can you hear us?
Yes, Mr. Chairman, can you hear me all right?
Certainly can. Go ahead, please.
Thank you, Mr. Chairman. Brett Moline, Wyoming Farm Bureau. I'm sitting against this resolution. My members believe that the current number of classes is sufficient. And in talking to some of my counterparts, especially, the part where you will divide up the different types of residential doesn't sit well, and we would not be in favor of that. So speaking against the resolution, Mr. Chairman, and I would sit for any questions, trying to be brief.
Thank you very much, Mr. Moline. Any questions for Mr. Moline? Not seeing any questions. Thank you for your testimony, Mr. Moline.
Thank you, sir.
Who else would like to address the committee on this bill? Assessor Huxtable, welcome.
Mr. Chairman, I'll try to be real brief on this. Create a multiple classification on one account, just so everybody's aware. I testified before that we do not consider mobile homes as residential real property, so not an issue, just a clarification point. I had the same note about the issue that Representative Ian brought, so I didn't have to bring that one up. Thank you.
Excellent. Questions for Assessor Huxtable? Any questions for the assessor? Thank you. And we're pretty sure we're online now? Right. Okay. Anybody else have any questions? Any public testimony here on this bill? Anybody else? Not seeing any public testimony. Is there anybody that was able to get our attention online?
Yes, Mr. Chairman, Lori Urbakite is online.
Okay, Ms. Urbakite, come on in.
Good morning, good afternoon, good evening, Mr. Chairman, members of the committee. I don't know if my video's on. Some days it works on this computer and some days it doesn't. But I am.
We do not have video, but we do have your voice. Very clear.
Okay. I am Lori Urbakite with the Wyoming Realtors. This is a constitutional amendment that the Wyoming Realtors have had on their public policy advocacy stands for, gosh, decades, probably before I even became affiliated with them. We have always believed that residential should be taken out, and so that indeed it could be treated differently. This one with the added language that allows the legislature to make a differentiation between primary residence and maybe a second home is a little of an interesting twist that we had not contemplated in the past. But again, it just gives the legislature that authority to look at that issue if they saw fit. So we are supportive of it, and I'd be happy to try and answer any questions.
Any questions from Ms. Oberkite? We got Representative Gray's got a question. Representative Gray.
Yeah, Ms. Urbakite, I have some language to also clarify in this amendment that acquisition value or caps could be authorized by the state legislature. And in my view, if we're going to handle this issue, we should also handle the lack of clarity on that, on whether acquisition value and a cap could be done. Do you think that adding that language would be a good?
Mr. Chairman,
Ms.
Representative Gray, I was really hoping not to have to testify on acquisition or caps, but since you asked, we'd rather not have that included in this constitutional amendment. I'd prefer that this be a very simple constitutional amendment that the general public will easily understand. And I think they will probably be very supportive of it as long as we keep it very simple and very clean.
Thank you, Ms. Oberkite. Any other questions for Ms. Oberkite? Thank you, Ms. Oberkite. Do we have anybody
Thank
else?
you.
Anybody else in the room? Committee, I'm not seeing any more public comment. You've heard the testimony. Oh, Mr. Kelly, come on up. You turn your microphone on, Mr. Kelly, and appreciate it. You should have a green light at the bottom.
I do.
Great.
All right, Mr. Chairman, since Representative Gray brought up acquisition, what we've witnessed this year or in the past couple of years is the fact that people moving into the state, purchasing product or purchasing homes for elevated prices, bidding wars, sight unseen purchases, which has taken our property values up tremendously, but now we're seeing them come back down too. With that being said, the people that are coming in here, we the people, and I'm not saying that, no, I can't afford it, but at the same time, there are people out there that cannot afford the increase that they're experiencing, the elder, the disabled. We need to do something about that too. With the acquisition, I believe that that's going to assist as far as with the property taxes and be able to cap what the increase is on all properties. Put a cap in place like many of the states that I see in your evaluation, and keep it there, keep it constant. Make it, and when she brought up the fact that people won't understand, make it simplified language that people will understand what an acquisition fee is, what the cap is. There's another thing that you might consider too is, I know somebody that purchased a home in Colorado at a resort. And after owning it for several years, they decided to sell it. Well, they implemented what was an exit tax down there. So once they sold their property, they had to pay the state of Colorado a certain percentage as far as what they had, even though they had already paid their taxes as far as property taxes throughout the years. So that's another possibility there too, to generate revenue as opposed to increasing it based upon a market value.
Okay, any questions for Mr. Kelly? Representative Yang.
Mr. Chairman, thank you. Mr. Kelly, so in the amendment, there's also language to allow for homestead exemptions. You think homestead exemptions will help keep people in their homes in Wyoming?
Okay.
Mr. Kelly, if you can.
Yes, Mr. Chairman. So the homestead exemption, Mr. Yen, or Representative Yen, would you please explain that to me?
Mr. Yen.
So, Mr. Chairman, thank you. Generally, it can vary depending from state to state, but the idea would be if you live in a home and you are a permanent homeowner in Wyoming, after a certain amount of time, you actually get a tax break. on your residential property. That's generally, but some states have income-based homestead exemptions, but the idea is for people who are staying here, living here long-term, full-time, they get a break compared to everybody else.
Mr. Keller?
Mr. Chairman, Mr. Urban, what period of time would that be for an individual to have ownership of that home?
So, Mr. Yun, I think you're just talking in generalities. aren't
Yeah,
you?
Mr. Chairman, thank you. So in the amendment, it just permits the legislature to implement exemptions. So it would be up to the legislature in the future to decide what that looked like. So it could be 5 years, it could be 10 years. But the idea is for long-term residents who are looking to stay in Wyoming permanently, that's who gets it.
And let's just be clear here that you're talking about when you say in the amendment, you're not talking about the amendment that Representative Gray just handed out. You're talking about the proposed constitutional amendment, which says, once the separate class is created, it says the legislature may create a subclass of residential real property for primary homeowners and may authorize exemptions that apply to primary homeowners or additional subclasses of residential real property as determined by the legislature by general law. So that's the proposed constitutional amendment, is to allow possible special consideration for residential properties.
So, Mr. Chairman, what that's stating is that you could, by law, determine what term you want as far as for a person to own that home, and then several years later, make a change to that because it's not set in stone, is what you're saying.
Right, it would be not constrained by the Constitution, because the Constitution would say the legislature can change these factors for residential.
Okay. Mr. Chairman, in this particular bill, the 20 LS 2332,
That's
do you have in there that you're going to study the acquisition fee,
No, we do not, but Representative Gray is proposing to do that. He's going to propose an amendment to tie acquisition value to this.
Okay.
Ms. Urbicite testified she thought that was a bad idea. That's where that notion came from. And he does have a proposed amendment written that he hasn't moved yet. I'm getting the cart ahead, about acquisition value.
Okay, and Mr. Chairman, the caps too?
Does it cover caps too? Okay, so he says it does, but we haven't considered the amendment to the proposed constitutional amendment yet.
Okay,
All right,
all right. Thank you very much.
thank you. It's been a long day.
Yeah, we get longer, I got a feeling.
Yeah, okay. Further public comment on the proposed constitutional amendment? Further proposed or further public comment? I'm not seeing any public comment. Committee, you've heard your discussion. Let's hear we've already been online, and is there anybody new online? Okay, that online too. So committee, what's your pleasure? Got a motion by Baldwin, a second by Henderson, and discussion on the bill. Any proposed amendments? Representative Gray.
Thank you, Mr. Chairman. I handed out this amendment during the break. It should be on your desk there. I want to run through what this amendment does. So page 1, line 3, it's just the enacting the initial bill description, amends that to make it conforming. Page 3, line 7 is the big change. And it allows for residential real property to have a maximum annual valuation increase, that's a cap, or for acquisition value to be implemented. So I want to be very clear in this language, it's permissive. It says that you would still need to pass a statute if this amendment passed with this language to implement either acquisition value, caps, or both working together. And then the page 4, line 11 is just conforming to make the ballot language conform with what we're doing in the meat of this amendment, which is page 3, line 7.
Okay.
So here's the thought on this. I guess I need a second.
Yep.
Can I?
Got a second by Jennings.
Thank you, Mr. Chairman. Could I go through a narrative of what I'm trying to
Yep,
do
go
here?
back to you.
Thank you, Mr. Chairman. I've been working on property tax for 3 years. I'm very passionate about it. Really, it's the main reason I asked to be on this committee. It has been pretty frustrating every time we talk about two issues of which there's a lot of passion in Wyoming about, caps and acquisition value. And ultimately, if you had an acquisition value system, you'd have to probably have a cap combined with it. And it's been a little frustrating that the first thing that comes up is that, well, it's not constitutional. I make the argument that it is, but it is very nuanced. And I would prefer for the Constitution to be very clear that it is allowed. And I think if we're going to handle this issue of breaking out residential property, we should also provide the option for the legislature to have caps and/or acquisition value in the future. So if this amendment passed with the language, it's not touching Representative Yin's language at all. That's still going to be there. But if this amendment passes, it adds into the amendment that caps and acquisition value are also allowed in the Constitution. So we come back, if this amendment passes in 2025, with three options on the table. One is to lower the assessment value below 9.5%. That's what's in the bill currently. Two is to have acquisition value, and three is to have a cap. And I guess four would be to have some combination of acquisition value and a cap. So we'd have a lot more tools in our toolkit. I think this problem is going to continue. And I would really ask the committee, I know I've been talking a lot, and I know people get a little angsty on this, but it's all come here in the afternoon and I'm passionate about it. So please consider this, because I think we should do it all at one time, and it's not requiring it. The other thing I'd say about the language in there now is it's very similar to the homestead exemption we gave. I mean, you lower the assessment rate, and then it helps on very high valued properties, but really it's a very similar approach to what we did at the last meeting to the homestead exemption. It's not the exact same, but it's similar. It's along the same route. It's exempting, or it's lowering the amount subject to assessment. This is a different approach, and I think it should be in the toolkit when the legislature comes back in 2025. I don't think it's going to be that complex. I actually think this language is less complex than the breakout. I agree you're adding, it's a similar topic, but a slightly different nuance to it. But I think caps and acquisition value is much less complex than the assessment rate. But rather than amend that out, I said, let's do it all at one time. And I think this is a good balanced approach. Thank you.
Discussion on the amendment. We got Representative Henderson.
Thank you, Mr. Chairman. I like this amendment up to the point where you talk about the empowering the legislature to be sensitive to the conditions in the economy and the valuation of the market. But I'm not in favor of tying or complicating it with acquisition. Some we could talk about later. But I would ask if you would consider it friendly to just put a period in the first part there, line 3 or page 3, line 7, on the third line of your amendment, where you're saying, after conditions insert and residential real property may be valued at less than full value as prescribed by the legislature through the implementation of a maximum annual valuation increase. I think that's good stuff. But then I would put a period and delete the rest of that. Similarly, on the other one, page 4, line 11, after assessments insert authorizing the legislature to prescribe that the value of residential real property may be limited by the implementation of a maximum increase in annual valuation changes. Again, good stuff, but I'd like to put a period and delete the rest of it. Would you consider that friendly?
Representative Gray, would you consider it friendly?
Mr. Chairman, I'd prefer to dispense with this one, and then we could do that next. Would that be okay? Could we do that?
Or we can amend the amendment. We can go down that road.
I'm okay with that, yeah, and then we'll just have a vote on amending the amendment. I mean, it's changing the amendment, and I understand, maybe we get something good moving in the right direction.
But you wouldn't consider friendly, so let's just either amend the amendment.
I propose to amend the amendment, as I just said.
Okay.
I get a second.
Can you do it slower? You were talking pretty fast.
So I was just trying to expedite.
I think we got it on the page 4, line 11, that
Right.
the period comes after the word changes on the 4th line. But give your amendment again on the part that's page 3, line
Page 3,
7.
line 7. after conditions insert and residential real property, which may be valued at less than full value as prescribed by the legislature through the implementation of a maximum annual valuation increase, period. I think this makes it very palatable for not just the legislature, but the people who are going to vote on it in our state in terms of understanding the clarity that it provides and what we're trying to do.
Okay. So you've kind of left in the concept of caps, but you took out the acquisition value.
Yeah.
So there's another way to skin the cat, and that would be to take the sentence that says, full value as prescribed by the legislature, period. So, and residential real property which may be valued at less than full value as prescribed by the legislature, period. That's even simpler, but I'm not going to steal your thunder.
Well, I think that makes it even more clear. Wouldn't you agree, Mr. Chairman?
Wait, I thought I was the chairman.
Trying to follow protocol.
Oh, so we have an amendment to the amendment, which I think has been supplemented with a friendly amendment to the amendment to the amendment. Would that be fair? Is my proposal friendly? Okay, was it friendly to the second? Okay, so I think what we have, the new proposed amendment would be after conditions insert and residential real property which may be valued at less than full value as prescribed by the legislature, period. And then similarly on 4 line 7, authorize the legislature to prescribe that the value of the residential or real property may be limited. That's not very good. That language is not tracking very well because that still applies at cap. In my mind, it says, may be limited by the implementation of a maximum increase in annual valuation changes. That's cap. But half a loaf is better than nothing. Mr. Co-Chairman.
Mr. Chairman, I think your friendly amendment to the amendment on lines 3 through 7, I think the part you took out, I think is probably necessary, because if you just read it without that, it doesn't really say anything about the caps. I mean, I think this is very specific, what was brought to us about implementing a cap.
Okay.
If you take that out, I think it can be anything.
Oh, I will
It can be
withdraw.
zero. I mean,
If you want to go down the cap road, I will withdraw.
I think that's the intent. but-
We're back to your original motion, Representative Henderson. Your amendment to the motion. Everybody get it?
Question?
I'm withdrawing my proposal. So now we're back to page 3, line 7, and residential real property which may be valued at less than the full value as prescribed by the legislature through the implementation of a maximum annual value increase, period. And then we have in the next page 4, line 11, in annual valuation changes, period. Delete the rest of it. Are we there?
Just voting to amend.
We're only voting on the amended amendment, then we'll have to take up the full thing. So all those in favor of amending the amendment signify by saying aye.
Aye.
Any opposed?
No.
Got it. Looks like that's carried. We're back on the main amendment, which is now amended. So it's on the full thing. Representative Yen.
Thank you, Mr. Chairman. So my only qualm here, I'll probably still vote for it now, but my only qualm is that it requires a 2/3 vote in each chamber because it's a constitutional amendment. I don't want to make it messier where there is a risk where groups will come out against it because it's going to affect local revenues, to become an issue where we end up failing the amendment in total. So that's my biggest qualm with the amendment. But I will still vote yes in the committee either way.
Okay. Further discussion? You can guarantee there will be plenty of opposition to this when it's on the ballot. So your other taxpayers will be opposed to it. You can guarantee it. Yeah. So further discussion? All those in favor of the amendment as it's been amended, please signify by saying aye.
Aye.
Opposed, no.
No.
I'm uncertain. All those in favor, raise your hand. Got 1, 2, 3, 4, 5, 6. All those opposed, raise your hand. 1, 2, 3, 4, 5, 6, 7. It has failed. Back on the bill. Any further discussion on the bill? It's a roll call. Please call the roll.
Senator Baldwin. Aye. Senator James.
Excused?
Senator Pappas.
Aye.
Senator Schuler. Aye. Representative Baker.
Aye.
Representative Gray.
Aye.
Representative Hallinan. Representative Henderson.
Aye.
Representative Jennings. Representative Roscoe.
Aye.
Representative Sweeney.
Aye.
Representative Yen.
Aye.
Co-Chairman Harshman.
Aye.
Chairman Case.
Aye.
That passes, Mr. Chairman.
Thank you very much, Emily. The next bill for our consideration is 23 LSO 268, Property Tax Refund Program. Josh, you could do it from right there if you want, Josh.
So, Mr. Chairman, Josh Anderson again. This bill was requested at our last meeting. This was one of the, another suggestion that came out of the Property Tax Working Group to look at changing the qualifications for the Property Tax Refund Program. So this bill, as currently drafted, makes two changes. First, it requires the applicant to have resided in Wyoming for not less than 6 months of the applicable tax year. And then the other thing the bill does, Mr. Chairman, is it changes the household income rate, which is currently 3/4 of the median gross household income for the county or the state, and removes that, so then it would be equal to 100% of the median gross household income for the county or state. That's the bill, Mr. Chairman. Take any questions.
Thank you. Questions for Mr. Anderson? Any questions for Mr. Anderson? I think you got off scot-free. Is there any public comment on this bill? Director Henson? Welcome.
Mr. Chairman, thank you. Members of the committee, Brenda Henson, Director of Revenue, and staff has just handed out the summary of the 2021 Property Tax Refund Program. I just wanted to ensure that you recognize that that's with current language, and what was provided, a little over $1.8 million in property tax refunds for 2021 property tax refunds. We believe that we're going to need an additional $1 million during the supplemental budget process in order to fund it for the 2022 property tax year. And this is just heads up. We'll be making that suggestion to JAC when we meet with them. But I wanted to let you know that whatever criteria the legislature deems appropriate for this program, our computer system that we have can be changed. If you want to change the income criteria, if you want to change the amount of the property tax refund that is able to be refunded to that property owner, we can change that. The asset number, that is certainly under the purview of this body in the legislature. So we can update all of those things for the 2022 property tax year refunds. And we can do a fiscal note at that time as to what the estimated cost would be with those changes. So truly, just wanted you to know that it was not going to be a concern for the Department of Revenue to alter this.
Okay, thank you. Any questions for Ms. Henson? Thank you. Representative Sweeney.
Thank you, Mr. Chairman. So do you know what number, I heard different numbers that the governor put in his supplemental. I had heard 8 million.
Director
Is that
Henson,
even close?
do you know?
Mr. Chairman, Representative Sweeney, I have not seen his recommendations.
Does anybody know if the governor's made a recommendation in the area?
Chairman.
Mr. Co-Chair.
I think it was just $1 million on that, but Mr. Chairman, I have a question for the director.
Go ahead.
Just, so if we modify this bill and with amendments, will you be able to get us numbers, fiscal note in the coming days, weeks before we?
Certainly. Mr. Chairman, now the
Go
most
ahead.
recent income information that I have is from the IRS, and it's 2019 information. That's what's published. So any estimates that we would provide would be based on that information, but definitely we can provide you with that.
Okay. Representative Baker. Go ahead.
Thank you, Mr. Chairman. Briefly, if you know, or if you can speculate as to why the number of applicants increased 2.5 times, is that just because of economic need, or is it based on education, that more people are aware of it? Thank you.
Director Henson.
Mr. Chairman, Representative Baker, all of the above. There was a definite effort on behalf of county treasurers across the state, the Department of Revenue. We did webinars, getting the information out, particularly since it hadn't been funded since 2019. And in addition, you can see that on the 2019 average dollar refund, statewide was $533, where this year it's $601, because each year the income numbers have increased, as well as the 1/2 of the median property tax, residential property tax bill. And we anticipate increases again when those numbers are calculated for 2022, even with current legislation, current statutory language.
Okay. Anybody else? Senator Schuler?
Thank you, Mr. Chairman. Actually, Representative Baker asked a couple of the questions I was going to ask, but one of them that I was going to ask was, do you think that the ones that were not approved, that were denied, was it because of their gross income? Or was it just the fact that they didn't fill out things properly, or just curious on that?
Director Henson?
Mr. Chairman, Senator Schuler, so if they didn't fill things out accurately or completely, we reached out to those taxpayers and tried to get that additional information. And in almost all cases, we were able to resolve that. So the majority of the applicants that did not qualify were due to income. We did have a few other situations, assets, they may have owned multiple properties. And every time the asset number for 2021 refunds was about $133,000. Of course, that's excluding the value of the house that you're asking for the refund on. It's excluding one vehicle per adult in the household. It's excluding any retirement, assets that you've got out there. But if you own a second home or you have rental property, those types of things, it does disqualify you from the program.
Anybody else? Okay, Dr. Hallinan.
Thank you, Mr. Chairman. I have a question. How much is the refund going to be? How much is the refund of the individual going to be?
I think it could be as much as half, but I'll let Director Henson address it.
Mr. Chairman, Representative Hallinan, the way the statute reads, it can be 1/2 of the property tax bill up to 1/2 of the median residential property tax bill for that county. So you'll see in the report that I've provided that the average dollar refund in each county is different because of market values. Income numbers are different based on each county. And so these are just the average, but you can see this goes the gambit anywhere from, I believe the lowest is $319.37. Oh, I apologize. It's $180.75, all the way up to $1,895.11, just depending on.
We know who that is. Got it, Doctor?
Say again,
Say it again.
Okay.
please.
Mr. Chairman, I'll use an example. Representative Hallinan, let's say my property tax bill is $1,500.
Hold that microphone close. That's part of the issue here.
For example, if the property tax bill is $1,500 and you live in a county where the median residential property tax bill is $1,000, the current statute says I can only get 1/2 of my property tax bill, up to the 1/2 of the average property tax bill. So if the average is $1,000, that means $500 can be refunded. Even if my property tax bill was $1,500, I can still only receive $500 of that back. But it does remind me of a point that the legislature did approve the county option property tax refund program, which is a completely different program, and the county treasurers can speak to the administration of that program. But definitely there is the possibility, because some of the counties have decided to fund that program for 2022 property taxes, there's a possibility that property owners could get 1/2, up to 1/2 of the median residential property tax bill funded by the state program. And they could also receive an amount similar from the county on their program.
Okay. Any other questions for Director Henson? Mr. Representative Hallinan.
Thank you, Mr. Chairman. So therefore, Niobrara County could only get $90 by 1/2 of their county average tax. $90.
Probably be right. Director Henson.
Mr. Chairman, the average dollar refund, as noted in that last column, is the actual refund. So it would not be taken in half again. I did not bring the pamphlet that has the income levels and the 1/2 of the median. I had provided those at the last meeting, but I certainly could bring those tomorrow if the committee would like to have that.
So Dr. Hallinan, this is the amount with the half already in it, in that column. So that's the amount they actually get. Now, Director Henson, if we take the median income up to the median instead of 3/4 of the median, do you have any idea how much that would cost?
Mr. Chairman, I have not crunched those numbers.
I'm just trying to think, it's a bell-shaped curve, right? So there's more closer to the median than there were below, probably. So it probably, it gets more expensive as you go up.
That's correct, Mr. Chairman.
Okay. And then, so everybody back to this bill, it does two things. It deals with part-time residents and says you got to live here at least 6 months. And then the second part is the take out the restriction about 3/4 of the median gross household income. That's two things this bill does, right, Josh? That's all it does. Yeah. So if you don't like it going up to the median, you might make a motion about line 18 on page 3. I'm kind of fishing, but I'm not getting anything. So you can go back. Thank you, Director Henson. I appreciate it. All right.
Mr. Chairman, real quick. Sorry, this is a little out of order, but I neglected to offer the amendment that fixed the ambiguity, and I wonder whether we should reopen it or I should just save that for the session. For the constitutional amendment bill.
Let's deal with that after this bill.
Okay.
We'll clean it up. It won't be that hard. Okay. Mr. Riemann.
Mr. Chairman, members of the committee, I'm Jeremiah Riemann. I'm here on behalf of the Wyoming County Commissioners Association. Do appreciate the work of this committee to offer the county option, and there are several counties that took advantage of that particular option last year. And it's that option that actually brings me to the table. As is mentioned, this bill does two things. One, it adds the requirement of 6 months in the state, and then, of course, take out the 3/4. If you look at the bill that you passed last year relative to the county option, which was Senate File 19, in that bill, you included a provision relative to the time of residency or time in the county in a particular year. And in that language, you put, the applicant shall attest that the property for which the applicant applies for a refund under this paragraph was occupied for more than 9 months of the preceding calendar year. So in the bill you just passed, you have 9 months. Perhaps you might want to have some consistency on that particular provision. Mr. Chairman, in this bill before you, you're taking out the 3/4. In the county option, you have the 3/4. So this may be an option or an opportunity to bring in the county option again and also take out the 3/4 if that's the direction that you're headed, simply so that there is consistency, because as was stated, individuals could qualify for the state program and then could qualify for a local program if it's offered in their county. And I think we'd probably want to avoid some inconsistencies amongst programs as much as we possibly could. So with that, Mr. Chairman, I'd be happy to answer any questions.
Thank you. Questions for Mr. Reaman? Any questions for Mr. Reaman? So basically, you're pointing out two things, the 6 months versus the 9 months, and opening up the other program to make it that go to median value if this one goes to median value.
Correct.
Gotcha. Thanks. Discussion? The only one that's on the table for you right now is the 6 months that change it to 9 months. That's an easy change, if you want to go that direction. Otherwise, we got to change the other statute, which can be done. Any further public comment on this bill? Any further public comment? Is there any public comment online? Let's hear from him. Mr. Moline, we're reaching out to you again.
Thank you, Mr. Chairman. Brett Moline, Wyoming Farm Bureau Federation again. I like the direction this bill is going. I appreciate that removing that income level. The question I have is on page 4, line 2, the total household assets of not more than $100,000. In many counties, like the county where I live in Albany County, that's not going to be much. As a question, is there a way that you can do that on a county basis rather than just having $100,000? Because as was mentioned before, in some counties, $100,000 is quite a bit more than what it is in other counties. Is there, given the information that we have through the assessors, what the average house is, the valuation, is there a way to incorporate that?
Mr. Moline, Mr. Co-Chairman would like to weigh in on this issue.
Mr. Moline, and I've got an amendment kind of coming later on this, so I've been looking at that, and the director talked about this too, and that dollar amount is per adult member of the household. So if there's 2 or whatever, that's 100,000 times the number of adults in the household. And it does not include, then the part of the statute that's not included in this bill that you can't see is the value of the home that you're in right now is not included. 1 motor vehicle per adult in the household. So if you got 2 adults, 2 cars are not looked at. None of your household furnishings or personal property, any assets that you have in an IRA or any other pension plan, the cash value of any life insurance, or any assets held in a medical savings account. Those are not looked at. So I hope that helped with some more information on it.
So, Mr. Moline, I think what the co-chairman is saying is that the $100,000 would exclude all of those things he just listed, as well as exclude the value of the home. And exclude the cars and everything. So that's, It's like after you get done excluding all that stuff, you still have $100,000. That's where you get bounced out of this program. But that's.
Mr. Chairman, thank you for that clarification. As another question, on line 4 and 5, we use the cost of living index. Is there another index? Because what we're looking at is how bad the property values increase. That's what's hitting people on concerning property taxes. And I don't know the answer. That's why I'm asking. Is there another index to look at rather than cost of living? Is there a cost of housing index? I believe there is, but I'm not 100% positive. That might be a better index than just looking at the general cost of living. With that, Mr. Chairman, I'd sit for any questions.
We're going to get Director Henson back up here to talk about the index. Thank you, Director Henson.
Thank you, Mr. Chairman. I want to cover two things. So the cost of living is specific to the asset number, and we've talked about the $100,000 number that's in statute. But as it states, it's adjusted annually for the statewide average Wyoming cost of living. But that is only applicable to the asset test. And so when we talk about the amount of refund, that is based on a maximum of 100% of the median residential property tax bill for that county. So that is actually taken into consideration every single year. In fact, when mill levies, if they go up in a specific county for whatever reason, that's included in that average tax bill calculation. So we have addressed the increasing valuations within each county with that mechanism within statute. And I hope that clarifies that for Mr. Moline.
We good? He's shaking his head, yes?
Mr. Chairman, yes. I apologize for dragging this out, not having that basic knowledge. Thank you for indulging me.
Consider yourself indulged. Anybody else? Okay, any other public comment? Anybody else online? Okay, committee, you've heard the discussion. What's your pleasure?
Move the bill.
I heard by my co-chairman, and I think I could give you the second. Would that be Representative Gray? Oh, Yen, I'm sorry. Okay. So Harshman and Yen. Discussion.
Mr. Chairman.
Mr. Co-chairman.
Mr. Chairman, I have a couple of amendments, and I really, we have a couple of these. This one, of course, administered by Department of Revenue. We have one that is, I don't think, quite as good a program. It's actually administered by the Department of Health. We haven't funded it since probably 2015 or 16, but I think we can. And I guess I sent the committee all that letter from a taxpayer and lives in Jackson, 96 years old, whose taxes went from $4,000 to $13,000. And then a lot of the comments I've gotten, it ought to be something when I turn 65 and I've lived in Wyoming in this house for 30 years. What can you do? And so how can we target this really to, so I've got some amendments for you, Mr. Chairman. With that in mind, that's what I'm going to try to do here. So Mr. Chairman, members of the committee, on page 3, line 18, where we've got those income limits, and the bill draft just takes the 3/4 out, so it's the median gross household income. And I put, my amendment there would be to move that to 125% of the median gross household income. So that's one way, and I guess because I got 3 of these, and it's probably better, I don't know, Mr. Chairman, how you want me to do it?
Why don't
want me
you
to do
go through all 3 and we'll
Okay.
come back and divide it up.
Okay, so then, members, if you go to the next page, page 4, line 3, I'd like to just move that asset amount up per adult to $150,000 from $100,000. And then I just sent you all an email for part of the statute that is not in the bill draft, but this paragraph that these 2 amendments come in as paragraph B. I sent you paragraph C. And that talks about the refund amount, and the director just talked about this, and there's, if you'll open that and look at that, there's two, it says a refund granted under this paragraph shall not exceed 1/2 of the applicant's prior year tax. So if you paid $4,000 last year, like the lady in Teton County, the max she could get would be $2,000. But her property taxes went up to $13,000. And she's 96 years old, been in there since the 50s, in the same house. And then it says, but in no instance shall the amount of refund exceed 1/2 of the median residential property tax liability for the county of residence. It's probably not a problem in Teton County, the average property tax. So my third amendment, Mr. Chairman, would just be to take that 1/2, where a refund granted under this paragraph shall not exceed 1/2 of the applicant's prior taxes, would not exceed 90%, is what I want to change that to. So those are my three amendments.
Okay, let's start at the top.
Okay, so Mr. Chairman, the first one's pretty straightforward. From the income that this bill draft moves from 75 to 100, I would just propose on line 18, page 3, to move that to 125%.
Is there a second? Second by Schuler.
Thanks, Mr. Chairman, for discussion. Basically, I would like to fully fund this program. If it costs us $10 million a year to grant relief to the poor, the elderly, the people who've been in their homes, been in Wyoming for a long time, I think, that's my goal with this, so.
Okay. Further discussion? Further discussion on 125? Everybody understand it? Dr. Hallinan?
I don't think we're really dealing with the poor when we're talking about 125% of the median income in that county. I think that we ought to keep it at the 100%. Thank you, Mr. Chairman.
Thank you, Dr. Hallinan. Are there further discussion? Further discussion? Ready for the question?
Mr. Chairman, I think poor is a relative word. I think when you're elderly and you're on a fixed income, you might have, and depending where you live in this state, it's for your county of residence. So 125%, in Teton County is not necessarily the same, but okay, fair enough. I'll stop talking.
Okay, further discussion on the proposed amendment to go from 100%, which is what the bill does, to take it to 125%. Further discussion. Okay, everybody understand it? Ready for the question? All those in favor of Mr. Co-Chairman's motion on 125%, please indicate by saying aye.
Aye.
Opposed, no? No. Okay, that looks like it's carried. Next one.
Okay, Mr. Chairman, on the next page, members, on page 4, line 3, at 100,000 per adult member of the household, to adjust that to 150 per adult member of the household.
And is there a second? Got a second by Schuler. Discussion. Again.
Mr. Chairman, thank you. So just for everyone's point of reference, that is it has increased based on a cost of living index, and currently it's at 133,651. So we just bumped it up basically 15,000 or so.
Okay, thank you for that. Further discussion, Sweeney.
Thank you, Mr. Chairman. So if the good co-chairman could explain, are we better off doing it that way or reducing the amount? I'm just mathematically not understanding the relative effect.
Mr. Co-Chairman.
Thank you, Mr. Chairman. I think by increasing it, you're going to include certain folks that might have some assets that would disqualify. I just think it opens it up to more people, Mr. Co-Chair.
Okay. Anybody else? Dr. Hallinan.
Well, thank you, Mr. Chairman. I guess I'm going to be the conservative on this committee. I think that $100,000 in cash doesn't equal a poor person when you have a car, when they have a house, when they have their other expenses taken care of. I think that we ought to limit the state's expenditure on this issue. Thank you, Mr. Chairman.
Thank you, Dr. Hallinan. Anybody else? Ready for the question? So the question is on the other assets, taking it up to $150,000. All those in favor signify by saying aye.
Aye.
Opposed, no? No. Back to you, Mr. Co-Chairman. That's carried as well.
Thank you, Mr. Chairman. And members, it's that email that I sent you, which is the next part. It's just under B. It is paragraph C in the statute. And this is probably the most important part, I think, particularly the letter that you've all read from Teton County. A refund granted under this paragraph shall not exceed 1/2 of the applicant's prior year property tax. So, so I'd like to amend that 50% or 1/2 to 90%. And it gives you the example of the lady in Jackson who paid over $4,000 and it went to $13,000 in 1 year. So
Okay.
if we don't adjust this, the max she will get is $2,000.
Okay, let's see if you got a second. Do we have a second? We have a second. Second by Sweeney. Discussion. Yen?
So,
Representative Yen?
thank you, Mr. Chairman. I'm thinking about this and it is, so it's a refund program, but one issue that will occur if we up it to 90%, and even if we keep the county optional one at 50%, you could get a more than 100% refund on your taxes that way. Which might end up becoming a concern if you can get a more than 100% refund on your taxes. So then we'll have to have some sort of circuit breaker, I think, if we do that.
Thinking about that, Mr. Co-Chair? Go ahead.
And Mr. Co-Chair, I think, and I think it'll be necessary then for these programs to kind of communicate and how that works. And I guess my thoughts were that that would happen, but I'm just thinking of that example of 4,000 to 13,000. So if this amendment passes, the person in Jackson could get about 3,000, some 3,500 from this program, 3,600 from this program, and 50% of the previous tax year, which would be about 2,000. So that'd be about 5,600 on a $13,000 tax bill. That's how I look at it. It's all previous year tax assessment. And what I'm trying to get at is this massive jump, right? That's of the previous tax bill.
Representative Yen?
Mr. Chairman, and this is basically the flaw of having a refund instead of an exemption, right? If we had an exemption, you wouldn't pay it at all. You wouldn't have to get the money back after you paid it from the previous year. So you wouldn't have this gap where you have to pay $18,000 and then wait till you can get $9,000 back in the next year. So I think with the county optional program, and Teton County is one that's funding it, that taxpayer will get 100% refund. And assuming they still qualify after the 18,000, they'll get the $18,000 refund, depending on what the median tax rate. I don't think the median tax rate in Jackson's actually $9,000, so they probably won't get $18,000, but they'll get twice whatever the median, 50% of the median is. I think ultimately we should focus on getting exemptions so we don't have to have these seniors pay this big tax bill at all. But I am worried that we're going to get into issues if we have this combination where we've refunded people more money than they've paid.
Okay. Further discussion, Dr. Hallinan?
Well, thank you, Mr. Chairman. I think that this fact that they could get more than the amount of property tax refunded that they paid, I think that pretty much rules out this amendment. Actually, I think we have to look at where this money goes. This property tax goes in major part to the school districts. And the school districts are going to be looking for more money. And I think they're entitled to get it. So I think it's definitely a good reason to vote down this amendment. Thank you, Mr. Chairman.
Thank you, Dr. Hallinan. Mr. Co-Chair?
Mr. Chairman, and I think probably in my explanation was a little short, that I think you have to keep reading the statute. And then the next sentence says, but in no instance shall the amount of refund exceed 1/2 of the median residential property tax liability of the applicant's county of residence as determined annually by the Department of Revenue. So I think that puts and I didn't amend that part intentionally on that. So I don't think there's gonna be a case anybody getting more than what they paid. I just don't, it's not possible. Secondly, this does not hurt local government revenues at all. The state is making this up. These payments come from the state. It's not a cut to the local government.
Okay.
And Mr. Chairman, I
Go
think
ahead.
that if we wanted to add another sentence, in the C, we could certainly do that and, direct the department to work with rules that in no instance will the total refund be over if, using both programs. And that can be done too, but I think this part kind of directs it at some of these people that have had these huge increases.
Okay, further discussion? Further discussion. You ready for the question? All those in favor of the third proposal by Mr. Co-Chairman Harshman, please signify by saying aye.
Aye.
Opposed, no?
No.
No. Let's see a show of hands. All those in favor, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8. Looks like that carried. So thank you very much. All right, back on the bill. Anything else on the bill? Representative Young.
Mr. Chairman, so I got an email from another Teton County constituent where the situation was, it's a family home, their kid lives in it, and their kid is the taxpayer and the only resident of the home. But according to the Department of Revenue rules, only the owner is eligible for the program. So if the kid is not the owner, but they are the taxpayer and would be otherwise eligible for the program, they wouldn't technically be eligible based on the rules that are currently enacted. I emailed the Department of Revenue and I'm happy to have them come up if they want to talk about it. But one solution that we could do is, while we're amending the statute, is also amending the ability for the owner or an immediate family member of the owner to be eligible. That's definitely a policy question, and I think I will motion to amend that. So on page 2, line 6, where it says showing that he, strike he and add owner or their immediate family member.
Is there a second? Got it by Roscoe. Discussion.
And so, Mr. Chairman, if I may,
Go ahead.
again, I think the policy question is, this is a family that's been in Jackson long enough to have their kid be able to stay there. But if their kid can't even afford, based on their income, to pay for the taxes in that house, they're going to have to leave. And that's something I think that we should want to prevent with this program. So I do think that this is something where it makes sense to have their immediate family members be eligible for the tax refund program.
Any further discussion? Any further discussion? Ready for the question? All those in favor signify by saying aye.
Aye.
Opposed, no. No. Raise the hands. All those in favor, raise your hand. 1, 2, 3, 4, 5, 6, 7, 8. It's carried. Okay, anything else on the bill?
Mr. Chairman,
Mr. Co-Chairman.
if I could ask the director too, I think Director Henson,
Director Hanson?
is there do we need a little language maybe to make sure these programs are communicating so we don't, we're trying to be intentional about directing this at these massive increases. And I'm looking at, paragraph C and
Director
E,
Hanson.
and how on E you promulgate rules and regulations necessary to implement the paragraph.
Director Hanson.
Mr. Chairman, Representative Harshman. So one of the challenges that both the state and the county treasurers have is that the language in the county option mirrors the statewide program in every way, except for these amendments we're doing today. So what happens is our timing is we're both administering this program at the exact same time. The applications are due at the same time. We both have the same deadline date for getting that check out. But you and I both know many, many times property owners wait until the deadline to get in those applications. So with the way these are structured right now, it would be a challenge because we'd both be processing at the same time. And to be making phone calls to the 23 treasurers across the state. Initially, when the county option bill was proposed by Representative Yin, the thought process was when the state of Wyoming does not have sufficient funds to fund the statewide program, then the counties, if they had the resources, they could put this. I don't think there was a lot of thought process behind that we were going to have these two programs simultaneously being administered statewide. So with your blessing, I would like to get together with the county treasurers prior to the legislative session and see if we can alter some of that timing. So for example, the statewide program, maybe our program has the current statutes, but the county treasurers are a month following or something. So there's a time period or a mechanism there where we know, first of all, what's approved at the state. We would then provide a report to the county treasurers, and the county treasurers would then act after that. But I need to visit with the county treasurers.
That sounds good. Thank you.
Representative Yan.
Mr. Chairman, I'll make a motion, well, I'll make two amendments, but I'll make the first one, which is to amend the required residing period to 9 months from 6 months.
Okay, is there a second? Second by Schuler. I'll give it. Schuler got it. She's so lucky today. All right, discussion. All those in favor of the motion to make it 9 months of residency, then which matches the county program, instead of 6 months? All those in favor signify by saying aye.
Aye.
Opposed, no? Oh, that was a move in the right direction. Finally. Representative Yan, you're on a home run here.
So, Mr. Chairman, thank you. So one other thing, which is I want to make sure that we have the ability to put in the county option statutes in the bill if necessary during the session. So I'd like to amend the title to add amending the county optional tax refund program.
Josh, can you think of a way to do that?
So, Mr. Chairman, one way would be to amend the county option to have the same income requirements that the committee just approved for the statewide program. So then that county one would already be in there, Mr. Chairman.
Would we be doing that with a separate bill, Josh, or would we bring it into this bill and just make them the same?
Correct, Mr. Chairman.
Actually, I like that because we get both of them on the same piece of paper, and we'd be looking at that. Are you okay with that, Representative?
Mr. Chairman, I am.
So your motion would be to bring in the county option into this bill and to make conforming amendments that match what we're doing for the state.
That's correct.
Is there a second? Second by Harshman. Discussion. Representative Sweeney.
Thank you, Mr. Chairman. So by bringing the county refund program into this one, does that mean that the counties would pretty much count on the state to pay both, or being it's part of the same bill?
Representative Sweeney, I think the county program is paid for by the counties. We're just bringing in the statutory language so that they're both in the same bill and we can make the conforming amendments about the eligibility, not about the funding. Everybody clear on that? So it doesn't have anything to do with the funding. It'd still be by the counties. Okay. Further discussion? Ready for the question? All those in favor of bringing the county option program into this bill and making conforming amendments that match what we've done so far, signify by saying aye.
Aye.
Opposed, no. Okay, that's carried. Representative Yan, you are on a roll. We're back on the bill. Further discussion on the bill. I have a question being called on the bill. Anybody else online, Emily? Got them all? Okay, let's call the roll on this one, and just by way of, I'm just going to explain my vote before I make it. and I'm going to be a no vote. I think we modified this bill too much. I liked it when it was the beginning, so I'm just letting you know that. Not trying to influence your vote, but, okay, Emily.
Senator Baldwin. Senator James.
Excused.
Senator Pappas.
Aye.
Senator Schuler. Representative Baker. Representative Gray. Representative Hallinan. Representative Henderson. Representative Jennings. Representative Roscoe. Representative Sweeney. Representative Yin.
Aye.
Co-Chairman Harshman. Chairman Case.
No.
That passes.
Thank you very much, Emily. So the next bill for our consideration is LSO 269, property tax increase limit. Josh, you want to do it from there?
Sure thing, Mr. Chairman. So this is 23 LSO 269.
Is your mic on?
Sorry, Mr. Chairman.
There you go.
This is 23 LSO 269. This was another bill that was requested at our September meeting. And what the bill would do, Mr. Chairman, is would specify that the all other property class, which is currently valued at 9.5%, would be limited each year to not increase more than 3% from the taxable value in the prior year, not including any value increase attributable to changes, additions, reductions, or improvements to the property. So this would put a 3% cap on the valuation of all other property class.
Okay, and then Josh, previously you had a chart about constitutionality. Is this one considered in that chart, and where does it land?
Yes, Mr. Chairman, there was that the matrix of options that was looked at by the working group, and this was in the category of the strongest argument of potentially violating the Constitution, Mr. Chairman.
Thank you very much. Public comment or pre-discussion? Let's hear any public comment on this bill. Ms. Assessor Huxtable.
Mr. Chairman, members of the committee, again, Dixie Huxtable, Converse County Assessor, and this is one that we do have some unanimous comments on. There was no support for this bill as it's drafted. The biggest concerns were the constitutionality. The other questions were the 3%, understanding that that's a placeholder, but they just felt like the 3% was not reasonable. There was a lot of concerns about limiting and defining change and all the things with this bill that it would that still need to be flushed out in the assessor's opinions. What there was unanimous was that it was a concept that needed to have conversation. We need to keep it moving. There was not support to pass it as it's written, but to keep the conversation go was unanimous. Everybody wanted to keep this conversation and concept moving, but it wasn't ready for prime time in the opinion of the assessors. And I would stand for questions.
Mr. Co-Chairman.
Assessor Huxtable, so the all other property, real and personal, that this is aimed at, not industrial, not ag, or certainly not minerals, right?
Go ahead, Assessor Huxtable.
Mr. Chairman, this does include ag.
Oh, it does include
As it's
ag.
written, all other, the only thing excluded from this is minerals and industrial. This would include residential, as it's written, all other would be residential, commercial, ag, and other, including personal property.
Residential, commercial,
Agricultural,
ag,
and
okay.
All other.
all
So
other.
it's not a residential cap, it's a cap basically on everything but minerals
Right,
and industrial.
and industrial.
Mr. Chairman, that's the way we read it. Yes, sir.
Okay, thank you.
Further discussion? Any more questions for Ms. Huxtable? Thank you, Assessor Huxtable. Anybody else like to address the committee on this bill? Assessors are like lining up. I would be disappointed if we didn't, but we will get to him next. Assessor Meyer.
Yes, Mr. Chairman, Pat Meyer, Park County Assessor. I do have some handouts for you. As you all know, I have been working on this for quite some time and did a study. If we have the time, I'd like to go over them with you. I have hard copies for all you, and it's all highlighted and so forth.
Committee, what's your pleasure? Let's do it. Hand it out.
I got nowhere to go. It's hanging here. I'm away from home already.
Thanks, Josh. Okay.
Mr. Chairman, it seems like when you're doing the research, you understand things a lot more because you've looked into stuff a lot more. From going from studying all 50 states to limited to the states that had tax limits, to researching them, to interviewing other states and seeing what they do and seeing about tax limits. I'm certainly not in support of the bill the way it's written, but as Assessor Huxtable said, I want to keep this going a little bit more. So if you look at page 1, we're listing both short-term ways and long-term methods. The short terms are veterans exemptions, deferrals, refund program, monthly payments, Wyoming's homeowners tax exemption that we have gone through. The relief on those could easily be managed by assessors by listing it as an exemption. As you see, this is sound policy through the Lincoln Institute as well as other ones of what we're doing for the short term. As far as the tax exemption, homeowners exemption, at one time, the department had figured out the exemption from the 80s and used inflation. We got a memorandum on that, and she figured out $432. I believe you're talking about a 50,000 exemption, homeowners exemption now, and that equals around 332,000, which for the troubled counties that are going up so much, as I will get to, that's not even a Band-Aid. We went up in Park County, at least, I mean, people were going up $1,500. So, I mean, that's nice. And it really helps the lower income people, especially if you keep that the same for everybody. It's more progressive. So the people with lower incomes, that homeowner's exemption is going to mean more for their property, especially lower priced property.
So Assessor Meyer, I'm having trouble here because this is a bill about a cap and you're kind of talking about all these other things. Can you narrow it down?
Yep. Let's just go to page 2. And I've highlighted for you, the Lincoln Institute acknowledges the pitfalls of Wyoming's rate-based system. A rate-based system begins with a given tax rate and automatically applies that to the annual taxable value. Such a system justifies taxpayers' fears that increased and assessed value will automatically translate to higher tax bill. And that's exactly what happened in a fixed rate state like Wyoming. Other states are budget rate states. When your values go up, doesn't necessarily mean your taxes are going up. They adjust if they don't need the money, they adjust the mill levy can go down while your tax value, so you're not paying as much in taxes. And this is throughout the United States. And when you hear truth in taxation, which is in these reports that I've sent you and so forth before, that's 12 states where if you're going to raise your budget, you got to go in front of people. I mean, it has to get voted on. But Wyoming can't get off the fixed rate system. I have discovered that. We would have to change how we value mineral production. Mineral production is valued at 100%, and you take the mill levy and that's what they pay right there. So if we start lowering mill levies, we'd lose so much money that we'd never be able to get back. So I don't see that happen in the school system. They're guaranteed their mills. So we all budget, but we're all budgeting for as much as we get. Fire districts, rarely do you see one lower their mill from the 3 mills. Hospital districts, I've never seen them take less than the maximum they could get. So we don't really have that option. So that would be really hard. Statewide, if you go to page 3 in the highlight part, statewide, since 1996, the annual increase in valuation of agricultural, residential, and commercial properties has averaged 6.83% since 96. The median increase has been 6.21%. This has paid multiple costs every year. This is the amount from which Wyoming counties have been budgeting services for decades, and the logic is that it can continue to do so. The number can be recalculated annually and is a sensible approach to assigning a cap on that. If you go to page 4, we attempted to show how you would make a constitutional amendment without being attorneys and stuff. We just took other states there before they changed their constitution, and we just copied it in. I'm sure the LSO would be going over that stuff and so forth, but that's what other states did. So we're just copying them right now.
So Assessor Meyer,
Yes,
we have a bill about a cap,
right.
and the LSO thinks it's not constitutional, basically.
Right.
And we do probably need to change the Constitution to make that happen. We do not have a bill to change the Constitution to make that happen. Are
Well,
you
if you
proposing-
change the Constitution on the other bill, wouldn't that change, and you pulled out residential property, wouldn't that be good then?
Possibly. Possibly. I
We
think
would have, I agree, we have to do that. I just want to give you the basis on how much we think the increase should be allowed, the limited increase and so forth. I can finish this up real shortly.
I'm counting on you.
Thank you, Mr. Chairman. If you go to page 6, you'll see the 24 states that use limitations and so forth. So it happens. I mean, it's around here. I know there's been some talk. If you go to page 7, you'll see this was from the Department of Revenue, the increases since 2014. When you go to the next page, we averaged them to the mean, including 2022, was 5.52 statewide. And the mean for 2021, if you excluded it, it was 4.19%. So that's what we have been going up. The next page was the study from 1996 that goes from 96, and it includes commercial, residential, and so forth. And again, residential property, the increase was 6.99%, so possibly 7%. The next page shows you the increases that the counties received. I have them highlighted. If you're on the right page, it was right there. You can see the ones that went up over 19%, 31, 23. And you got to remember, like in Park County, although we averaged around 25%, they went up as far as 45%. You know, people were getting 1,200 increases, were normal, 800, 1,500, and so forth. So that was the problem. So a lot of it is we're fixed on getting as much money as we can. If you look at page 11, you'll see the valuations. We went up in value from 2021, almost $7 billion. $7 billion is like 470 extra million that you didn't have the year before. Is what I'm saying on that. But the last page is really what I want you to look at. We modeled this after Arizona's because it was a good model. And we've had a lot of dialogue with them and so forth. But full cash value is the same as market value. Limited property, and that's what you get on your assessment schedule. You'll have fair market value and limited taxable value. So we're still valuing property the same way. Under Rule A, limited property value, under no change circumstances, nothing happens. If you had a 5% cap on it, that's all you could go. If you didn't change anything or anything went wrong like that. Rule B, limited property value under change circumstances. Previously omitted property would go to market value. Property that has a change of use since the previous year, possibly. Property that has been modified by 15% or more of its full cash value. So if you got $100,000 and you haven't put in $15,000, nothing changes. You still stay with the limited property value. Property that has been split, subdivided, or consolidated would, I imagine, that would be a change and go to market value. Now, Rule B is one of the changes set forth above has occurred. The property does not go to full cash value. The new limited value will be at the same ratio of limited property values of the full cash values of similar properties. So that means even if you buy a new house, you don't go to what you paid for it or fair market value. It gets looked at other like property with their limited property value. So you don't have that problem of when one guy in the same house is paying way more money than the other guy. This makes it all uniform the way Arizona did that, and would definitely be a thing. And I got these rules, and I had sent you all a copy of Chapter 3 Arizona rules. It's like 26 pages. These rules have already been done for us. I mean, we wouldn't want to invent the wheel. I mean, you look at these, they cover many of the attitude. I'm sure we'll find some cases, but I think in general, it would be done for us. We wouldn't have to go and redo everything. Other states are doing it. This takes away a lot of problems of people's tax. This stops it. And if you're in a county where it's lower values, that's okay. If limited tax value can never exceed market value. So if you're luckily, your county doesn't go up that much, 3 or 4%, you're fine, so you're good there. And you'd want to keep that rate open. You wouldn't want to lock yourself in the one rate of 5%. You could annually adjust that rate periodically every year. Now, Park County, I'll use Park County for a ratio. We went up higher than we ever have before with the 25 to 45%. But we also, our value in 2021 was $626,294,645. That's what it's been staying with for the last few years. We went up this year, $874,635,153. So we gained all that extra money too in 1 year. Now, a lot of that was from the property taxes going up, but it was mainly from oil and gas valuation. When you're paying $5 at the pump, Wyoming does good. And we're going to even do better this year. I've been keeping track of the monthly payments. We've already exceeded our 1 year valuation last year on oil and gas property, and we did it in less than 7 months. So that's going to happen too. So everybody's going to have a lot of money this year. And of course, we all know that changes. I'm not saying, but we
You
have.
promised me you'd be short and you'd get back to the bill.
This is it. So if we would have if we had a limit on 5%, using that as an example of last year's, if we didn't allow anybody, we'd still have been over 800 million, and that's more than we've had since 2015. That's what I'm saying. Limitations can work. They're working in 24 other states. I'd like to keep this conversation going. I'd like to get residential property off by itself, and I'd like to look into this because this solves a lot of problems for you. And it all goes to how much money do you need? Do you have to have it? This would almost be like budgeting for your needs. I mean, if you needed more money in residential property, I guess you could raise that rate and they would go up more. And we'll see from there. But that's all I'm asking, Mr. Chairman and members, is to keep this open for a while longer. I've got more research. I'd like more conversation. I kind of rushed this as much as because I felt like I had to, Mr. Chairman.
So Assessor Meyer, do you agree that the bill that's on the table right now needs a constitutional change to be a companion to?
Of course. Yes. There's
So
no doubt about that.
So,
But I'm saying, can't we put it wouldn't be done till 2024 anyways, in the election year, because it's got to go to a vote. I just want to keep this on the table.
I think Assessor Meyer, what you're misunderstanding is that we all want to keep it on the table. We all want to do this right.
Okay.
We want to help everybody. But you're taking us down a bit of a rat hole because right now we have a bill that's open on the committee. And we need to get to where you're going, I think. But it is it's almost 7 o'clock, and we're going to dispose of these issues tonight. We have a bill that's open on the table, and this bill is not constitutional, but we need to dispose of it, and then we can decide where folks can bring a constitutional change to facilitate it along the lines you're suggesting.
Understand.
It's kind of a cart before the horse thing, you know. And I'm just trying to get the people out of this room done today.
Understand.
All right, questions for Mr. Meyer?
Mr. Chairman?
Go ahead.
Just real quick on a lot of these, say the property's going up 8-9%, your cap's at 6%, so you're getting behind 3% a year, getting behind 3% a year. In most of these states, then you have a down year of 0. Do you catch up then, or do you just stay at that until this property's sold and then it resets the clock again?
Assessor Meyer.
It doesn't Mr. Chairman, it doesn't reset the clock at all. You'd still be at limited value. One thing is, with market crashes, it can't go below market value. So yes, you can't go below market value. And there is those possibilities, but over the years, we've averaged 6-7% increases. So, and we've had crashes. There were years, if you look at that chart from 96, you'll see that we didn't go up at all. And even when we went down a little bit. But
Let me just
Go
focus
ahead.
this in, Mr. Chairman.
Let's bring this
So, yeah, I'm gonna bring, so the cap's at 6%, my property, mine was 17% this last year, like state averages see, and so, but mine got capped at 6%, let's say, and then, so it's under market value.
Right.
Will it ever return to market value?
yeah, when the market goes
How about
down-
through the chair?
Mr. Chair, Mr. Chairman, when the market goes down, yes, it would. You might never catch up with limited tax value. You might
Yeah,
never catch
gotcha.
up to market value.
Thank you.
Thank you. Any further questions for Assessor Meyer? Thank you, Assessor Meyer.
Okey-doke.
Any further public testimony on this bill? Mr.
Thank you for
Reamy.
this. Good stuff. Thank you. Appreciate your email too. Appreciate your work. Good stuff.
Mr. Chairman, members of the committee, I'm Jeremiah Reeman here on behalf of the Wyoming County Commissioners Association. I will take a good hint and cut my presentation short, but I do think that I have some information that can really hit at the question that Representative Harshman just asked. I did have a presentation passed out. I'm going to skip over most of that discussion. I'm happy to go to talking points relative to them if you like. There are certainly some important pieces in here. But I'm going to go in particular to I'll start with slide 8. What I wanted to do is model out what this particular legislation could mean in terms of revenue to the state of Wyoming. And let's be honest, 70-some% of this goes to the schools. 17% or such comes to counties, another portion to special districts, and another portion to municipalities. What I've done here on the top of this chart is show you what happened between 2019 and 2022 relative to assessed valuations. And what you can see is that, of course, we had a total valuation in 2019 of just short of $23 billion. As was just stated in the previous testimony, that did drop to just under $20 billion in 2021, and we've certainly rebounded. So I think it's important that we not just think a $7 billion reduction. We had a $3 billion reduction the year before. We've certainly rebounded. There's no doubt about that, and a great deal of that credit goes to our mineral industry. Relative to valuations across the state. $4 billion change between that 2021 and 2022 period. But what I wanted to do is really show you what I found in the first part of the table that's right below that. So what I did is assumed that every year between 2019 and 2022 that the assessed valuation went up by 3%. Which is conceivably possible, and I wanted to see what the difference impact was relative to what actually happened. If you look over there on the right in the very bottom columns, you would have lost $1.6 billion in assessed valuation in comparison. That's roughly a 15% decrease, and that's only holding the all other category to that 3%. The others stay the same because that's what this bill does. That's a pretty big number and something that you all would have to consider relative to schools. And certainly my constituents are going to be banging on your door saying, where are we going to find the change? I think another piece that was really interesting to me in this data is you look on that far right column of 2022, the percentages, just under 45% of the value that year was attributed to minerals. If you make this change, that would have shot the percentage up to just under 48%. So a 2 or 3% change, which again makes us more dependent on our mineral industry to help pick up the tab. Mr. Chairman, I went to a second scenario, and that's on slide 9. And what I did here is said, okay, 2019, we're going to keep that as actual. Now we're going to assume that there's a 3% decrease that happens, and we've had that happen. I think in the data that you may have just received in 2010, across the board, there was a 3% plus decrease. We could be seeing that here in the not too distant future. I think some people are predicting that might happen. So I suggested that between 2019 and 2020, we're going to have a 3% decrease in the all other category. And then from thereafter, we're going to increase it by the 3%. What you do find is that in that scenario, it takes you 3 years just to get back above the number that you started from in 2019. That's pretty telling. So it certainly lingers. As you see, the impact went from 1.6 billion up to $2.6 billion and a 24% decrease in that particular category. And then you look at the mineral dependency. We went from 45% mineral dependency up to almost 50% mineral dependency. I think that's an important thing for us to think about. So with that, Mr. Chairman, the only other thing I'll mention is that LSO has suggested that had this been in place between 1993 and 2022, a $4.67 billion decrease, On the county side, that's $794 million, or about $28.4 million per year. You're currently appropriating just over $18 million in direct distribution to counties on an annual basis. Now we'd be asking for another 24 million, maybe more, on an annual basis. I don't think that's something we want to look at. With that, Mr. Chairman, I'll cut the presentation short, but I hope that that's of value to you. It was certainly telling to me about what a limitation like this might mean.
Thank you very much, Mr. Reaman. Questions for Mr. Reaman? Representative Jennings.
Thank you, Mr. Chairman. Just a quick observation with a question in it. So one of the most interesting things that I've heard today was Assessor Meyer making an admission that there is an actual problem out there. I understand that you don't like the drops and the huge swings and stuff like that, but do you also see that there's a problem out there to John Q. Public when you have such radical swings like this? Do you see that same problem?
Yeah, Mr. Chairman, Representative Jennings, it is an important issue that we have to deal with. I think you dealt with one mechanism in terms of refunds. My members were given that option, and some of them did take that up. Some of them reduced their mills. I also think that there are other very valid options to ensure that we give broad-based tax relief. The homestead exemption that you all took up last meeting is an important way where we all could benefit from it. It is certainly a pressure, but I do think that this particular mechanism is really dangerous. And in particular, it's dangerous for my smallest counties, taking over, Bob. The smallest counties where a good year might mean that they deal with a deferred maintenance issue. And this particular proposal will hurt them the most.
Further questions for Mr. Reaman? Further questions for Mr. Reaman? Thank you, Mr. Reaman. Any further public testimony on this bill? Mr. McLaren? Remember, we're all on LSO 0269.
Mr. Chairman, I'm Bob McLaurin with WHAM. Just be very brief. Want to echo what Jeremiah stated. I believe it's my understanding that this would affect cities and towns to the tune of about $93 million. We do agree it's an issue that needs to be addressed and look forward to working with the legislature. In my own personal situation, I was just calculating on the back row. My property taxes in Jackson have gone up 208% since 2019, went up 40% last year. So we recognize it's a problem, not just in Jackson, but statewide. Look forward to working with you.
Questions for Mr. McLaren? Questions? Thank you.
Thank you very much.
Thank you, Mr. McLaren. Anybody else like to testify on this bill? Online? Mr. Moline? Okay.
Mr. Chairman, Brett Moline, Wyoming Farm Bureau, having policy on both sides of this, supporting the Constitution, but also supporting a cap. I realize this bill is not the mechanism to do it, but I look forward to further conversation to somehow institute a cap on the increase in property taxes. This has hit agricultural property pretty strong a few years ago when the price of hay skyrocketed. With that, Mr. Chairman, to try to be brief, I would sit for any questions against the bill, in favor of the concept.
Thank you, Mr. Moline. Questions for Mr. Moline? Not seeing any. Thank you, Mr. Moline. Ms. Zerbekeit, are you on?
I am, Mr. Chairman.
We see you now, too.
I know. I'm so
Go ahead.
happy. Mr. Chairman, Lori Zerbekeit with Wyoming Realtors. I'll be very, very brief. We believe that this is trying to solve a problem that was kind of an anomaly over the last 2 years with all the influx of new people coming into Wyoming, probably because of COVID, maybe because they love our Wyoming winters. But nonetheless, the 3%, regardless of whether it's constitutional or not, regardless of whether there's a constitutional amendment to fix this, 3% is way too low in our opinion. We have always kind of operated on the concept that real property in Wyoming appreciates 10 to 12% a year. And so should our taxes. So the percentage amount, I think, needs to be increased substantially. I don't think we need to go backwards, and I don't think we need to take money away from our counties and cities. They provide valuable services. So we would encourage an ongoing discussion, but the percentage needs to be substantially more than 3%. And I'd be happy to try and answer any questions.
Thank you. Any questions for Ms. Zerbekai? Any questions? Not seeing any, Ms. Zerbekai. Thank you very much.
Thank you.
Any other public comment? We got anything online? Anybody else in the room? Committee, that's it for public comment. What's your pleasure on the bill?
I move the bill, Mr. Chairman.
I think I heard it from Jennings with a second by Gray. Discussion. Representative Sweeney.
Thank you, Mr. Chairman. I still haven't learned how to do some of these things, and but is there a way with this bill draft to turn this into a resolution for a constitutional amendment?
I'm sure it would be possible if we weren't at 7:10 on the day. I think we could. There are plenty of people on this committee that have the horsepower to bring a resolution on this topic, and they can use the pattern of the other resolution and just, modify it to allow for the caps. And that's what, I know that's what Representative Gray wanted to do, but I think there's people that want not to roll everything into one. So, but there certainly is that power. I don't see an easy way to do that tonight with this one.
Mr. Chairman,
Representative
if I
Gray.
may, Representative Sweeney, I mean, I think they're going to reopen that constitutional amendment, the amendment that Representative Henderson and I brought failed by one vote, and I do think you were on the prevailing side, so we could work on that and still get it done tonight. I think it's better to wrap it into one. We've just saw that once you have 3-4 constitutional amendments on the ballot, it gets worse. I mean, it's really in the property tax issue. So I just think we add that very simple language we just voted on, and we can handle this issue. I do think it's constitutional anyway, but I would rather be clear on it. And I guess in a moment, we'll probably get into that debate, and that we had back in 2021, but there is a solution still possible tonight. Thank you.
Okay, thank you. Further discussion?
Mr. Chairman, if I could.
Representative Sweeney.
Thank you, Mr. Chairman. So the overwhelming majority of folks I talked to really wanted to see some sort of a cap talked about and acted on. So in thinking about it, and I don't disagree with Ms. Zerbekai, and I've said that repeatedly, that percentage is, in my mind, too low, just as the assessor said. But with that, Mr. Chairman, I would like to see something move forward. I just, am unclear on mechanisms and percentages, I guess. Thank you, Mr. Chairman.
Right, everybody. So look, we have a bill that it's arguably not constitutional. Representative Gray disagrees. And I think Representative Gray would agree that maybe the way we should go is to have the constitutional change that would accommodate this approach. Then we'd all be clear on it. I think staff has suggested that constitutionally this one's on thin ice. So we could just dispose of this and deal with the constitutional issue, and then we've got, plenty of time to come up with an actual bill to follow the Constitution. So what's your pleasure?
Well, thank you, Mr. Chairman. I think if some of the people that voted against that amendment would change their vote, we can revote that issue and we can deal with that right here now and then.
So
we can deal with that bill right now. Thank you, Mr. Chairman.
Thank you. So with respect to LSO 269, which is a statutory imposition of caps. We've got a motion on the bill. Are you ready for the question on it? Dr. Hallinan.
Thank you, Mr. Chairman. I have a couple of amendments on this bill. I know that the bill's probably going to be voted down anyway, but I think that we ought to try to perfect it a little bit.
So Dr. Hallinan, if some of us think it's unconstitutional, maybe we just do a straw poll. Why would we waste time trying to build a bill that we can't pass? That's would be my point.
Well, I think that the assessor brought up the issues and he wanted to see this bill discussed. And I think we could do that. We could do, we don't have to do this. I just think I would make some amendments on this bill that would improve it. Thank you, Mr. Chairman.
And somebody correct me if I'm wrong, but I'm having trouble. Why, if we don't have the constitutional foundation to make this bill possible? Representative Gray disagrees with me. Why would we continue with this bill? I don't disagree with the things that Assessor Myers brought up, but our fight is about the Constitution and to getting the bill right later. Let's hear from Representative Henderson.
Thank you, Mr. Chairman. So is it possible within the rules to go ahead and dispose of this and then have a reconsideration on the other?
Absolutely. It's totally on the
Make
table.
Make that how we want it, and then put it to bed to move it forward.
Right. And then,
That would be my motion.
well, we got a precedential motion on this bill, but certainly that is possible. And Representative Yen has already indicated that he wants to call for reconsideration to make the change. And I believe, did you vote on the correct side? Can you make that motion on the other bill? So we do have the mechanism for making that motion and open that bill up and adding the cap language back in that Representative Gray had suggested earlier, as well as make the correction that Representative Yen had talked about.
Mr. Chairman.
Representative Jennings.
So the reason I moved this bill, just so that it's clear, is because there's a John Q. public out there and they want to see this debate continue on. And there's question marks as to the constitutionality and will be on other bills also. And so I just wanted to bring that forward in the debate, that they want to be heard. And so if we move this bill forward, this bill will be questioned about constitutionality many times on the floor should we move this forward, but at least the
Absolutely.
debate continues. Thank you, Mr. Chairman.
That's fair. Any further discussion? So you ready for the question? Okay, Emily, would you call the roll on LSO 23 LSO 269, property tax increase limit?
Senator Baldwin? No. Senator James excused. Senator Pappas?
No.
Senator Schuler?
No.
Representative Baker?
No.
Representative Gray?
Aye.
Representative Hallinan?
Aye.
Representative Henderson?
No.
Representative Jennings? Representative Roscoe?
No.
Representative Sweeney?
Aye.
Representative Yen?
No.
Co-Chairman Harshman?
No.
Chairman Case?
No.
Mr.
Okay.
Chairman, that does not pass.
We are open for motion of reconsideration. Who's going to make that? Representative Yen.
So, Mr. Chairman, before I make that motion, I do want to say, I really want us to be careful again. It requires a 2/3 vote. We're going to get ratepayers. We're going to get taxpayers attacking us on the other taxes if we start messing around with more. So I want us to be very careful. But I will make a motion to reconsider and pair that with a motion for an amendment to make the change. Do I need to make these as separate motions, Mr. Chairman, or?
I think we can let's just have it reconsidered. I think there's kind of leeway.
Okay.
I mean, in a very technical sense, reconsideration is redoing the last vote, but we all know there's a problem with the bill. So with your leeway, let's open it back up and then let's address first the amendment that we have to address. And then we'll do we'll entertain an opening of the caps amendment.
You need a second on that motion?
Be fine. Is there a second for the reconsideration? We've got it. So it's Pappas. So, and that's actually kind of technically be a roll call, but it should be just a majority, so let's just do that. So all in favor, please raise your hand. 1, 2, 3, 4. I've got 5, 6, 7, 8, 9, 10. It's reopened. Okay, back on the bill. Representative Yen.
Mr. Chairman, so I
And everybody that's following online, if we reopened 23 LSO 32, Residential Property Taxation Amendment.
Mr.
Representative.
Chairman, so I move to make an amendment where it says higher nor more than 4 percentage points more than the percentage prescribed for. The new language is residential real property. So after residential real property, add or more than 40% higher nor more than 4 percentage points more than. And so that just mirrors the same language for both residential property and all other property.
I get it. Which page Representative Sweeney's asking?
Page is, hold on.
I don't have that bill up.
Yeah, I also didn't have the bill, just the amendment. Hold on.
It's on like page 3.
Yeah, it's,
9, 10, 11, 12.
yeah, the,
Page 3, lines 8, 9, 10.
yep. Say it again, Representative Yen, then we'll get
Okay.
your second.
So on line 10, right after residential real property, add or more than 40% higher, nor more than 4 percentage points more than.
All other.
That's fair.
Well, then it'll fit in with the rest of the new language.
Got it. Okay, is there a second?
Second.
Got a second by Hallinan.
So, Mr. Chairman, this removes all the ambiguity to ensure that there's never going to be a situation where the industrial is not linked to both residential and all other.
Josh, do you agree? It's good language? Good enough? Any further discussion? All those in favor signify by saying aye.
Aye.
Opposed, no. That amendment is carried. Any further amendments? Back to you, Representative Gray.
Thank you, Mr. Chairman. So going back to the proposed amendment, 23 LSO 32. Page 1, line 3 would remain as laid out in the written amendment. Page 3, line 7 would have a period after the word increase. So it'd be annual valuation increase, period. So it would remove the acquisition value part, but have the caps in there. And then in page 4, line 11, on the third line, it would say in annual valuation changes, period.
Got it. Second by Henderson. Discussion. So as I understand this, I think if this were to pass the voters, it would allow for a cap program like was discussed in the last bill and like Assessor Meyer was talking about. Okay,
Chairman?
Mr. Co-Chairman, and then we'll go to Representative Jennings.
Mr. Chairman, I voted for this last time. I just want to, is there any thought about putting, after looking at our long-term history, it's about 6% per year, and putting some kind of cap like that in the Constitution of a 6%. I'm just throwing that out there for discussion.
Mr. Chairman.
Representative Sweeney?
So as I understand the amendment, it would then leave it up to the legislature to determine at a later date, which I think would be, it's a little dangerous, but at the same time, I think it's more understandable by the general public, and gives the legislature more time to perfect that once the.
On that? Josh, you okay on that? Representative Henderson?
Thank you, Mr. Chairman. Just adding to the discussion, I think the important piece here is the biggest impact, my understanding is the year-to-year, increase or impact on the wallet, the change. And this second one, page 4, line 11, kind of covers that. And as we go forward and work this in the next session, I think there's opportunity to take a much closer look at it. Thank you, Mr. Chairman.
I think you're right, Representative Henderson, but I think page 4, line 11 is in the ballot statement language. So that's kind of the sales pitch to voters. That's not the binding law. The binding law would be page 3, line 7. Okay. Okay on that? All right. Any further, let's do a question. All those in favor of this amendment, please signify by saying aye.
Aye.
Opposed, no. I think it's carried. Anybody want a division? Okay, so that's carried. Back on the bill, would you recall the roll on the bill?
Senator
Let's
Baldwin.
wait, let's just make sure. Is there anything else while it's open?
Raise hand.
Okay, we're gonna back up and they want this division. So the question is, I want to raise a hands on the last motion. So all those in favor of the motion with the caps, please raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9. It was plenty good. My voice vote was excellent. Okay, that definitely carried. Anything else on the bill? Call the roll on the bill.
Senator Baldwin. Senator James excused. Senator Pappas.
Aye.
Senator Schuler.
Aye.
Representative Baker. Representative Gray.
Aye.
Representative Hallinan.
Aye.
Representative Henderson.
Aye.
Representative Jennings. Representative Roscoe.
Aye.
Representative Sweeney.
Aye.
Representative Yin. Co-Chairman Harshman.
Aye.
Chairman Case.
Aye.
That passes.
Okay. All right. The only thing left on our deal is property tax working group, right? Report from them. Working group update, acquisition
Yeah.
value study. Who's going to handle that?
Okay. Thank you, Mr. Chairman. I am so excited about that constitutional amendment. That was awesome. So the thank you, Mr. Chairman. Am I recognized?
Yes, you are.
The working group, which was Representative Jennings, myself, and Senator James, we met, it was about 2.5 weeks ago. And pursuant to what we discussed in the last meeting, we laid out, based on the recommendations of the DOR and the county clerks, we had county assessors, we had communication with both of them, what we would do into this acquisition value study, what we would amend in to give it some specificity as to what we're looking for, the questions, so that when we go out, if we're going to pay for this study, and it's an investment by the taxpayers of the state, we're going to get something back that we really can be proud of. And so we want to do, those were the questions that were laid out in this report. Now, in the written report, there was one typo on the second page on subsection B. The study would be reported back to the committee not later than September 1st, 2023, not 2022. That's just the date. Obviously, that was an error. And then subsection C, it would be the 2024 budget session rather than 2023 general session, because we don't have time to bring out this report and consider it in a month. And obviously, we couldn't pass the bill in a month because we are not in session. So that's what basically this does. It lays out that language to give some teeth to 2022 House Bill 109 and some specificity, which is what I think the committee was kind of thinking we would do. Do you want me to run through each of these questions, or I know everybody can kind of just look at and most of it was suggestions from the DOR. There were also some suggestions from the assessors, and then some that the members of the subcommittee brought. We thought it was very important, and in section 1A, we kind of bring this out, that we want this study to come back with how other states have done this. And there is one other state that has done this. And they've addressed all of these issues, because just like there's a lot of complexities here, there's a lot of complexities there. And so it's not like we're the first one to try this. So we wanted to make sure on each of these questions, we made it clear that they would give some examples from a state that had actually implemented this about how it'd been done. And then also lay out 3 scenarios on that, so they would be concrete, because in these studies, one of the problems with them, I think, is that, they're not concrete enough a lot of times. And as policymakers, I just think it's really important that they come back with a product that's really specific onto how this looks T to green. So that's the language in subsection A, which includes that idea of that bringing it back to 2017, having that inflationary kicker, and then moving to acquisition value for any other properties that change hands after that. And we asked for that to be one of the scenarios that they consider. And ultimately, I think the overall solution would be, in my mind, to have a look back in time with an inflationary kicker for that intervening period, plus moving to acquisition value for sales that occurred after a certain point, meaning after a bill was passed, because I think you have to have transparency on that, and it's difficult to do a look back on that. So this is just the language we suggested to try to bring some specificity into a study. Thank you.
Thank you. Any discussion? Representative Jennings?
I'll make one more little tiny plea to that. I thought it was very interesting that Assessor Myers had spent so much time in doing a study here and done all kinds of things, and I applaud that. And I think that we as a governing body, we have an obligation to be the most informed that we can be. And I know there's a lot of people here that say, oh, well, we shouldn't go to acquisition, or we shouldn't do this, or we shouldn't do that. But it seems to me like we had Assessor Myers, and then Mr. Ryman both of them made an admission that there's problems out there. And so I look at this study as, I don't know that this is the right answer. And I know we don't know what we don't know yet. And so the study, this is a small price for getting some answers. Maybe the answers that come out of this won't be applied to acquisition. Maybe they'll be applied to Assessor Myers' solutions to some of this, but we won't know if we don't go look at it. And so I'd ask the committee to move it forward.
Okay, I need a housekeeping moment here. I did jump over monthly payment of property taxes. I know that we have people here to testify. I'm hoping that it's going to go really fast, and we will get to that. So stick around. Thank you, and thank you. So back to this. Any public comment? Committee, what's pleasure?
Mr. Chairman, could I ask a question before we go to this?
Okay.
So in my understanding on the memo, what's the concept on the look back? What, I didn't quite catch that as far as going back to 2017.
Who can answer that?
So, Mr. Chairman, we wanted them to lay out 3 concrete proposals. I think it's really important for these consultants to be concrete, and that's in A. And then we also said that we would like them to consider this as one of the 3. Remember back in our subcommittee, Representative Simpson and Senator Dockstetter, their document, one of the ideas was to have a look back period, right, where we've had this tremendous increase, at least in Trona and Teton, since going back very long. And then this, in the last 2 years, this really pronounced increase the whole state. So the idea that was discussed in that meeting back in the summer was to go back in time, say to 2017 would be my preference. I think Representative Simpson wanted 2019. And if this was an amendment, you could change the date. And then you'd have an inflationary kicker for those intervening periods of 2 to 3%. So say it was 3%, you go back to 2017, everybody's property taxes go back to their 2017 levels. And then they calculate 3% compounded each year from there to where the present is to when we implement this change. And that's where people's assessments are at. And then from then on, you move to acquisition value. So you're covering both situations, people's whose properties are staying with them for the rest of their lives is being covered by that look back with the inflationary increase that would continue moving forward. And you're moving to acquisition value, which is a very transparent way to do it for people who are purchasing their properties. But, you know, doesn't fix the past, certainly. And so that was the idea. And it came out of Representative Simpson's document there from that, I think it was June meeting.
Anybody else? Is there any public comment on this bill?
Mr. Chairman, I apologize, I don't have the bill. All I had was the email with the asking of the questions, the list of questions. I never saw the memo that you're referring to. But the concerns we had was the look back. Bearing in mind that from the point that this could possibly pass and go forward, we physically inspect property once every 6 years. Some of that property could have been inspected 2 times over the course of this, and trying to figure out the changes that occurred. I have no idea how we could go back into our system from two field reviews ago and try to figure that out. So I'd really be cautious about going back to a lookup period of 17 when we're looking at least, 6 years or more in that lookup. I don't know how we'd go back and get all those changes documented.
Okay.
I just don't know how we do that.
And Assessor Huxtable, just to be clear, you have not seen the memo that they're talking about.
That is correct,
Right.
Chairman.
So where are we on posting that memo? Josh, do you remember?
Mr. Chairman, that was posted to our materials earlier today.
Okay, so it only happened today.
Mr.
So there
Chairman.
you have a legitimate thing. Yes.
Ms. Huxtable, the memo is basically the questions that I sent you. Okay, so, I mean, that's in slightly legalese form. Okay, so.
Mr. Chairman, thank you. Representative
Assessor
Gray.
Huxtable.
I knew what the list of questions were. I knew what we had questions about the questions.
Right.
And then we had offered some additional comments, and so I didn't know what was included in your memo. The one that flashed most was the 2017 for the look back period and trying to get our system, if that were to be the chosen look back period, caught up and accurate for our proper valuation. So that was the concern that we had.
Thank you, Assessor Huxtable. So members of the committee, I'm having a little bit of difficulty thinking we could move this bill along and amend it. We've got a working group that has worked on it and a good group of sponsors from before. I might suggest that we let them bring that bill as a private bill.
Mr. Chairman, I'd still like to move the bill. Let's get the committee's opinion to it. I mean, the amendments are out there. If you're to that point.
Is there any further public comment? Go ahead.
Mr. Chairman, yeah, go ahead.
One at a time. Representative Yen.
Mr. Chairman, are there notice requirements for bill drafts?
Certainly there are. This is a bill that we had previously in the committee, and I would encourage us to vote no and not go down this road. But majority of this committee could do anything they want.
Mr. Chairman,
Representative Sweeney.
before we do that, could I ask a question? With the complexities in the laundry list, is there any idea on cost? I know Director Hanson had mentioned that, not knowing, it would be tough to try to estimate, but it would help a little bit. I mean, is this $100,000 study, or is it 50,000, or is it a couple 100,000? Because Mr. Chairman, I have no clue.
I think the department has testified previously on the bill that's on the table, but go ahead.
Mr. Chairman, Representative Sweeney, you're right. We actually went out to a couple of consultants that would do this type of work based on the bill that was in place. And they would not give us any idea because they had so many questions. And so that was why we provided the questions. I believe with the amendments, perhaps we might be able to get a fiscal note prepared, that it might be a very broad fiscal note, but it will give you some idea.
Thank you. Any further questions for Director Henson? Thank you, Director Henson. Back, I think we have a motion. Do we have a second? Motion and second. Further discussion on the bill? Mr. Co-Chairman.
Chairman, I think there's one state that does this, it's California, I think, is that right? California? I mean, there's a reason, I think, but regards to that, I think this thing come as an individual bill, and so I'm gonna move to table.
Okay. The motion to table is it takes precedence of the main motion, so all those in favor of tabling the bill, let's raise your hand. 1, 2, 3, 4, 5, 6, 7, 8, 9. I see people in the audience raising too, but they don't count. So the bill is tabled. The market value deal, Josh, help us with that. I guess with monthly payment of property taxes, Wyoming County Treasurers Association. Remind me where this bill is, Josh.
So, Mr. Chairman, this wasn't a bill. This was a discussion item that came out of the property tax working group. It was discussed briefly at the last meeting. And the discussion was that we might need some input from the county treasurers. And so that's where we are, Mr. Chairman.
Welcome to Revenue at 7:41.
Thank you,
We're
Mr.
grateful for
Chairman.
you being so patient.
I'm Emily Parvasini. I am the Sublette County Treasurer, and I am here representing the County Treasurers Association. We did discuss this a week ago, and pretty much across the board, the consensus for the treasurers was no. And not because we want to be meanies, because it would actually, if it was to be something that was changed into law for us to accept monthly payments across the board, we would all have to hire additional staff. So it would cost the counties more money. Some of us already take monthly payments from folks who have made arrangements with us with the acknowledgement that if that first half isn't received in full by November the 10th, that they're going to have some interest on the preceding payments. You know, if we change this as far as legislatively, you know, does that include mortgage companies? Because that would be a different kind of a situation as well. We do recommend, if you wanted to mandate something like this, that it be a 9-month equal payment instead of 12, so that the final payments are received by May, so that we don't have those last 10, 11, 12 payments received in a different fiscal year. Having those fiscal years bleed into the next year means, just for instance, I reached out to the Teton County Treasurer, and for them, because these payments are distributed to all of the entities, the school would be shorted over $6 million just with 2 months worth of payments. The general fund for the county would be shorted over $3 million just with those 2 months. So a 9-month payment schedule would make more sense just to keep it all in the same fiscal year. If payments are missed or late, we recommend that those interest payments go back to either November 10th or May 10th versus just for that month, as though the first half was late rather than just a monthly payment. Due to costs, some people already ask us to send monthly bills. There's just no feasible way for us to do that. We send out one bill. It has 3 payment coupons, one for a November payment, one for a May payment, and one for a payment in full. There's just no way economically that it would make any sense for us to do a monthly payment schedule where we mail something every month. It just would cost too much money, aside from having to have additional people in our offices to stuff envelopes, basically. And then the last thing I wanted to mention, if we did do a 12-month pay schedule, right now, the statute mandates that we have our tax sale prior to the first week of September. So if we're not receiving payment 11 and 12 until July and August, and say it gets lost in the mail, and then we do a tax sale, and then we get their payment, now we have a big problem. So that's another thing to think about when you think about doing a 12-month payment schedule versus a 9-month payment schedule, or leaving it as it is for now. And then, like I said, having those folks reach out to us. If they want to make a monthly payment, we certainly have the ability to do that. Most people have a mortgage, so they don't have to really think about it. We get those payments from the mortgage companies on a regular basis anyways. But for right now, we across the board feel like budgeting is not something we should have to do for our constituents. It would be better served if they put that money in a savings account monthly and paid us twice a year. Thank you.
Okay, questions for Treasurer Parvasini?
Yes, thank you,
Thank you.
Chairman.
All right, questions for the treasurer? Any questions? You waited all this time and
Thank you.
you stole the
Have a
show.
good
with-
evening. And I don't want to see any of you after 8 o'clock.
Okay. Anybody else on that issue of monthly payments? Anything from the committee on monthly payments? Okay. Anything else coming before the committee tonight? Okay, we're adjourned until tomorrow morning at 8 o'clock.